Good afternoon. Good afternoon, and welcome to the Judiciary Committee. My name is Senator Justin Wayne. I represent Legislative District 13, which is North Omaha and Northeast Douglas County, and I serve as chair of the Judiciary Committee. We'll start off by having members of the committee and staff do self-introductions, starting with my right, Senator Ibach.
Thank you, Mr. Chairman. I'm Teresa Ibach. I represent 8 counties in Southwest Nebraska, District 44.
Good afternoon, Terrell McKinney, District 11, North Omaha.
Good afternoon, Megan Kilty, legal counsel. Antonina Pierre-Lewis, committee clerk.
Hi, my name is Wendy DeBoer. I represent District 10, which is in Northwest Omaha.
Good afternoon, Senator Carol Blood, and I represent District 3, which is Western Bellevue and Southeastern Papillion, Nebraska.
Rick Holcroft, District 36, West and South Sarpy County.
Good afternoon, Barry Decade, District 40. I represent Holt, Knox, Cedar, Antelope, northern part of Pierce, and most of Dixon County.
All right. And the pages today are Logan Bartek from Norfolk, who is a political science and criminology major at UNL, and Isabel Cold from Omaha, who is a political science and pre-law major. This afternoon, we'll be hearing 5 bills, and it will be taken up in the order listed outside the courtroom. On the tables in the back of the room, you will find blue testifier sheets. If you are planning on testifying, please fill out a blue one and hand it to the pages so we can keep accurate records. If you are not planning on testifying but would like your present known and your position known, please fill out the gold sheet in the back of the room. Also, I would like to let you know the legislature policy is all letters of record must be received by the committee by noon prior to the day of the hearing. If you have handouts, please hand them to the pages. We would like for you to have 10 handouts. If you don't, we'll get copies and make sure everybody gets it. Testimony for today will begin with the introducer statement. After the opening statement, we will hear from supporters of the bill, and then you'll hear from opposition, followed by those speaking in a neutral capacity. The introducer of the bill will be given the opportunity to close if they wish to do so. We ask that you begin your testimony by stating your first and last name, spell them for the record. We will be using the 3-minute light system. Today, it'll be green, it'll turn yellow with 1 minute left, and then red will ask you to wrap up your final thoughts. I would like to remind everyone today, including senators, please turn off your cell phones or put them on vibrate. And with that, I will turn it over to Senator DeBoer.
Senator Geist, would you introduce yourself since you've joined us?
Absolutely. Suzanne Geist, District 25, which is the east side, southeast side of Lincoln and Lancaster County.
Okay, well, now we will have Senator Wayne introduce LB 18.
Thank you, Vice Chair DeBoer. My name is Justin Wayne, Justinwayne, and I represent Legislative District 13. I told you guys this morning that I wasn't going to be here, but after talking and thinking about it, this is probably one of the most important bills that I continue to introduce, and I hope this year we can craft whatever kind of amendment needs to be done. You're going to hear today about the story of Ernest Jackson. And let me just, because I got to get to Omaha for a sentencing hearing, I just want to put it this way for people who don't understand the criminal justice system. You may watch on TV where somebody's in courtroom and they come up and they say, you did it, or did you do it? And they take the Fifth Amendment. That in reality never happens in the courtroom. Typically, you will know if somebody is going to plead the Fifth Amendment. And if you know, well, you always know typically, but if you know somebody's going to plead the Fifth Amendment, it is an automatic mistrial to do that in front of a jury. That's just what the Supreme Court and case law have said over and over and over, because it's an undue prejudice to either typically the prosecution, because it casts a shadow of doubt on everything. So what did that mean? That means in this case, Ernest was arrested first and his case was going first. There were also 2 other co-defendants. One of the main co-defendants, who was represented by another attorney, repeatedly said he will not testify, he will take the Fifth. So by that person using their constitutional right to the Fifth Amendment, Ernest couldn't call him to testify, nor could his attorney, and have that conversation about what really happened. Mr. Jackson was found guilty, and I'm abbreviating it because there are going to be people who are going to go into detail, and I don't want to steal some of their thunder, who have been working hard on this. But what essentially happened is he was convicted of murder, but he as an accessory, if you want to be simple terms. It's more legalese than that, but it's considered basically an accessory of a felony, of a murder. Well, the person who was ultimately responsible for the killing got up in his own trial after Ernest's trial, testified, and the jury believed him it was self-defense. And he was found not guilty. The third co-defendant, who was the last one to go, also went in front of a jury, and that individual testified of what really happened. And that third defendant was found not guilty. But because of a constitutional right, something we all sit here and argue and believe in, a constitutional right was exercised, and he happened to go first, he was convicted. That's essentially what happened in this case. That's essentially the dynamic of what we're trying to address, is that if somebody uses their constitutional right to not incriminate themselves and somebody is convicted who could have used that testimony, and then that person later tells their story, and you can file for a motion for a new trial. Now, I want to be clear here. This does not let somebody out tomorrow. This gives a person an opportunity to file a new motion for a new trial, which has to be heard in front of a judge. And we heard a lot of this talk about discretion yesterday. This gives the judge discretion on whether to grant a new trial or not. This is not an automatic get out of jail free. This is not an automatic new trial, because there are other facts a judge can look at in a case and say, even with the testimony that was barred from a constitutional right, I still don't think there's enough evidence to grant you a new trial. That's what could be said by a judge. But right now, based off a Supreme Court ruling, we can't even get in the door to make that motion for a new trial based off of this evidence, because the Supreme Court said it's not newly discovered. It's not newly discovered because we knew about it. When I say we, I'm not his defense attorney. They knew about it, but they had no way of accessing it because the other person's constitutional right that he exercised forbid that from happening. So not only is he convicted of a crime in which everybody else was found not guilty, to be a co-defendant where everybody else was found not guilty, that one is an injustice. But two, there was no way for this evidence to come to light. You can't compel somebody to testify against themselves in a Fifth Amendment situation. So it is new evidence for practical purposes. And this bill is simply trying to remedy this. Every year we have worked on amendments to narrow it to where it doesn't, in the prosecutor's mind, maybe opens up a floodgate. And we're going to try to work on narrowing it some more if we have to. But there is a true injustice being served right now. That the actual person who fired the shot, one, said Ernest wasn't there, but two, more importantly, convinced a jury it was self-defense. So why is somebody sitting in jail for a murder that was never a murder? Now, I don't know if there's another person underneath the exact same facts, but if there is, they still should have access to a new trial. There was no way for that evidence to come in. And with that, I will answer any questions.
Are there any questions for Senator Wayne? I don't think there are.
I will waive closing because I have to go to Omaha for a hearing. If the hearings are still going on later on, Vice Chair, I will drive back down. But I appreciate everybody's time and appreciate it. Thank you.
All right. Let's have our first proponent testifier. Welcome.
Hey, Jason Whitmer, WITMER. I only wanted to go first because I decided to read the statement of verbatim statement of Shalimar Cooper Ryder, who is the young man that was acquitted. So I'm having them handed out the first page I wrote on. So in this thing, I'm not sure if Shalimar is the killer. They seem not to give no thanks, possibly can, but I'm pretty sure Shalimar's killer is in this documentation that it had verbatim which is why I kind of found it questionable when they kept trying to undermine Ernest by saying there was multiple shots and nobody's talked about this. So to get to it, you heard some of the facts of the case. Shalimar trial was about a year after Ernest Jackson. He confesses to having a gun. You will see on, and I won't go verbatim for everything. You'll see that the prosecutor walks it through it. He has a 9mm. It's in like page. I got notes in there. You'll see it. He has a 9mm. I'm just going to talk about it and then you can read it. He has a 9mm. So I read this last night. Let me say, this has me frustrated because I don't know how 2 years has passed about talking about this case, and none of us have really read this, including myself. So there's a big reason about the 9mm. They talk about what happened. He went to confront or talk to Larry Perry, the young man that was killed. Everybody's about 18, 17 years old at this time. He's already said Ernest Jackson wasn't there under questioning. This is just partial of this bill exception. He already said Dante Chillis was not there. In fact, who he says was there while he's talking to Larry Perry is on the front page. I'll let it be read by you guys. It's two individuals are from the same neighborhood that Larry Perry is in. One of them he can't identify, he don't know. The other one he does know as a friend and he identifies. Him and Larry Perry's argument is about rims and tires getting stolen. These two individuals show up, they're mad at them for both being loud in the neighborhood, and then they get mad at Larry Perry for stealing rims and making the neighborhood hot. He decides to leave, Shalimar. Shalimar leaves, they ask him, the prosecutor is walking him through this. He crosses the fence, he's ending up down into the wherever this field he's at, and that's when he hears shots. They say, different sounds? He says, yes, different sounds, shots, meaning, from my tape, different guns, right? He runs, he jumps down on the ground. They ask him, to shoot back. He says to try not to be shot. Do you have questions?
Are there any questions for this testifier? Senator McKinney?
Thank you. Mr. Whitmer, if you like to, do you have any closing statements you want to say?
Yeah, I do. Thank you. He says, try not to be shot, but he says, I do turn and return fire. I see 3 individuals. It's asked again, because there's multiple times, as you guys who are lawyers know, you go over and over this, that the individuals are spread out. He says he takes shots at them. They ask about 4 or 5 shots. He gets up and runs. He sees 2 of them running and 1 of them fall. Whether or not that's from him or from the others, but I know the prosecution or whoever represented him have come up here and eluded, but would not say no detail about multiple shots, which always confused me. Do you guys know what happened to Shalimar and Dante Chillis, who was acquitted? Within 5 years, they were both murdered, unsolved murders. Do you think all murders are random? Because I don't think so. I think somebody knows that life sentences can be hit any time in your life. That murder cases stay forever. I think what I say could get me killed, but it don't matter because it's in the record. You can't kill what's in the record. And if you look at this, somebody's identified, somebody's not investigated. We have a prosecution team that often gets people who they are prosecuting, and once they do, they stick to it. They won't mess up their case to pull other things in. If we have somebody out there that we talk about accountability, Don. And I think it's time that we do accountability. Like, this case needs to be investigated. But as far as Ernest Jackson, no reference to him being a part of this other than him being friends with the individual. And he's still in prison.
Let's see if there are any other questions. Senator McKinney, are you done asking questions?
Yes.
Thank you. Are there any other questions? Okay, let me ask you a couple of questions just to kind of set the stage for everybody, because I think we're kind of coming in the middle of things here. Who was the individual who was killed in the first instance?
Larry Perry.
Larry
was
Perry.
The young man that the defendants is Shalimar Cooper Ryder, Ernest Jackson and Dante Chillis were charged with use of the felony murder rule. So they're charged with first degree. The felony murder rule only requires that you're convicted of a felony or believed to acted in felony manner, and that links you to first degree without premeditation.
Okay,
So
so Larry
Larry
Perry's-
Perry was the one that was
there was-
killed in that case.
Larry Perry was the victim of the first shooting, and the document that you gave us was
Shalimar Cooper
transcript
Riders.
from Cooper Ryder's
Trial.
trial. Yeah, okay, thank you.
And his lawyer may even be here. Tom Riley. can
I
vouch
see
for
no-
this.
Mr. I see no other questions for you. Thank you very much.
Okay.
Let's have the next proponent testifier. Yeah.
Name's Jonathan Lathan, Jonathan, last name Lathan, Lathan. Good afternoon, Judiciary Committee members, here to hear this bill, LB 18. I'm here to speak to you today as a proponent of LB 18. Although this bill covers more than the case I'm familiar with, Ernest Jackson, I'd like to take some time to speak on it. I grew up in Omaha. I ran some of the same streets as Ernest. I actually grew up in church with Avery. Fortunately, I was able to enlist in the military before I found myself in a similar situation as those individuals. I'm a father of 9, 6 of my children being boys. My oldest is 19. He hangs out with friends, spends time with his family, and plays video games, just like Ernest. I keep excellent track of where he is, but just as with Ernest, a case of mistaken identity or allegedly being at the wrong place at the wrong time could cost him over 20 years of his life. 20 years away from family, 20 plus years away from friends, losing the opportunity to be physically present, raising children, losing the opportunity to be a free man. I couldn't imagine my son being taken away from me, initially based on seemingly inconsistent charges and convictions. Ernest was found guilty of first-degree murder, but not the use of a weapon to commit that murder. On top of that, he's still incarcerated even after the actual shooter was acquitted of that same murder on the charge of self-defense at his own trial that he was able to testify at and didn't take his constitutional right. That trial happened to be after Jackson's. Even with the knowledge that another person confessed and was acquitted of that murder, Ernest is still in jail. State law has prohibited this information from giving Ernest a new trial, basically because of scheduling. LB 18, allowing the testimony of a party who exercised their constitutional right to not speak at another trial, could be the key to freedom for a lot of individuals who are just pawns in the system. Ernest had his trial first, and his legal team asked several times for Cooper Ryder, the shooter, to testify. Those requests were denied because it would potentially incriminate Cooper Ryder because his trial was set for a later date. This is why we're here today. If Ernest had been given a trial after Cooper Ryder, the verdict of self-defense would have counted. Ernest would potentially be free. That's not the only evidence that should be considered, though. An eyewitness placed Jackson at the scene, hitting the victim on the head with a pistol. The autopsy showed that not to be true. The witness that saw Jackson at the scene, but did not know it was Jackson until police told them. There are also many inconsistencies that LB 18 are paramount in bringing justice to these families. We live in a society of second chances. We now have a second chance to make this right. For Ernest, Avery, and every other inmate who may have similar circumstances. We talk about justice. We talk about how important family is. We talk about doing the right thing. Well, now's the time to do the right thing. Vote to pass LB 18 for Ernest, for Avery, for their families. For our sons, who even though we may be good parents, they end up being in a situation and be taken from us for 20 plus years. Ernest is just one example of countless others who this bill could bring justice to, who deserve a chance at a retrial. Thank you.
Thank you very much. Are there any questions for this testifier? I don't see any, but thank you very much for being here.
You're welcome.
Let's have our next proponent testifier.
Hi, my name is Nature M. Villegas, Nature, middle initial M, last name Villegas. In the past few years and even days of legislation hearings, I've heard phrases I visualize as coward shields to hide behind. Public safety, tough on crime, what about the victims? In the miraculous year 2020. We can put the shields down, playing naive is over. This isn't something that bled out of 2020's Band-Aid. This is a genocide against our men, women, and children in our community. A genocide Nebraska loves to sweep under the rug with the infamous good life broom and refuse to take accountability. Nebraska's residents are required to be more accountable than the state itself and the operating officials. While LB 18 would not necessarily hold Nebraska accountable, it would give human beings that Nebraska has so easily thrown away a chance for a new trial based on new evidence. We have spent the last few years hearing senators and other people in prestigious positions say, we know Ernest Jackson is innocent, but our hands are tied legally. Well, LB 18 will allow you to get from behind your comfort shields and your privilege and untie your hands. LB 18 would allow Ernest Jackson and many others you are holding that are innocent a trial and chance to be returned home. If you can know you have innocent life in your systems and not do something to bring that change to the law, to assist them to be returned, what does that really say about your true character and your true morale? We will not, as a community, continue to sit and let you take our men, women, and children or kill us. I was able to speak to Ernest yesterday, and I was so humbled because I sit before people that cast so much judgment, that do not hold a candle to his integrity, his wisdom, his peace, his kindness. It's uncanny. I have yet to see it in the people that want to turn down their noses at us. I see Avery's family behind me. I've heard their family, him speak. We need our kings out here, and they deserve to be home. They deserve this change in our system so they can be home. Otherwise, what is this justice you speak of? And this system you have so much faith in? Those of you that hide behind your shields and privilege don't hold a candle to the loving, peaceful, kind, wisdom, and integrity filled in our kings and queens and our children that you are holding hostage. I want you to say his name because we are speaking highly of Ernest today, but I want to close this out in his words of much love, more respect, and all power to the people.
Thank you. Let's see if there are any questions for you. Are there any questions for this testifier? I don't see any. Thank you for being here. Let's have the next proponent testifier. Are there any other proponents? Okay. Welcome to your Judiciary Committee.
Thank you. Good afternoon. My name is Amber Strozier, Amber Stroz, like zebra, IER. And thank you for your time in hearing me today. I am here representing Inclusive Communities of Omaha. I am also coming on behalf of Ernest Jackson and Avery Tyler. I'm a wife. I am a mother, a homeschool mother of 6 children, ages ranging from 10 to 4 months. I am a daughter. I am a sister. I am an Omaha native. I come in support of LB 18. It must be passed to serve as a check and balance to the courts that have gravely been misinterpreting the law at best. When making decisions on denying, granting new trials based on newly discovered evidence. As it stands now, there is a loophole that exists simply because of a word play on semantics that says that newly available evidence is not the same thing as newly discovered evidence, even in layman's terms saying you knew this. So therefore, there is no way that it can be newly discovered. But we cannot take common sense out of the law and out of the courts. The fact remains that the defendants did not have access to this evidence during trial or even subsequent appeals. What happened to Ernest Jackson should never have happened at all. 20 plus years have gone by, but we must not miss this opportunity to make it right now. And passing this bill would allow for the opportunity to do just that, because newly discovered must be synonymous with newly available. Also, I am coming to shed light on a similar injustice with another loophole in interpreting the newly discovered evidence directly affecting my brother, Avery Tyler. Avery is a son, a brother, an uncle, a father with a master's degree. At the time, he was manager of Mutual Omaha and currently prison chaplain of NSP, co-founder of CAP program, and overall support to the men in NSP. Please follow me for a moment. In 2014, Avery was convicted of first-degree murder and sentenced to life without the possibility of parole on a clean record with nothing on it. 2 months later, he requested that all transcripts be sent to him through his attorney. However, he was only sent a cover sheet and not the transcripts themselves. The Nebraska Supreme Court says that a copy of the transcripts, all requested transcripts, where it's going, and a copy of everything be sent, that was sent, be put into the court file so that a defendant could not come back and say, hey, you never sent it to me. All that was sent was a cover sheet. He reached out many times before his deadline, and with
Ma'am,
his...
I'm sorry, I'm going to have to interrupt you because your
yes.
red light's on, but I'm confident there will be a question for you. Senator McKinney.
Thank you. Can you finish your last statements?
Yes, absolutely. Thank you. So my brother Avery Tyler reached out many times and was never actually sent all of his records from the court. The court system is a check and balance against lawyers or against lawyers as well. And this check and balance did not take place. It was violated. My brother did not receive the actual files that he requested. And so my brother had a deadline to meet. He met the deadline for the post-conviction appeal, yet he could not bring any claims from records that were never given to him. 2017, and I'm almost finished. 2017, he requested officially the records again, and the clerk of the court on the last page wrote that the files originally requested in 2014 were not a part of his court file, proving what my brother has been saying all along, that he did not receive it. Finally, in 2021, he requested again the entire file, and I called and I requested, spent much time with the clerk, who apologized and looked through every single request and finally said, I have it and I will send it. She sent it, and what we suspected that something was wrong, there was. My brother found out that his speedy trial had been violated and that his attorney, who was the head of the defense, I might not be saying the proper terminology, but the head of the public defenders knew of this and actually aided in doing so. It is our opinion that that is the reason why the file was never sent to my brother until it was too late. So on subsequent appeals, my brother was told, denied. Your attorney had it, you had it, therefore, and so this is not newly discovered evidence. But this did not leave my brother with an option to bring forth ineffective assistance of counsel claims without the information. So this is a loophole that I'm asking to be closed, to close this loophole that allows the courts to suppress claims of defendants by withholding records until after the expiration of deadlines to file claims. So I'm asking that you pass this LB 18 and also that it be amended to include language that deems records and transcripts that were expressly requested by incarcerated individuals after trial, not sent, to be classified as newly discovered evidence in relation to claims of ineffective assistance of counsel when transcripts are provided. There is no way that claims can be brought forth without access to the requested record. Finally,
Okay, let's see if there are any other questions for you. Are there any other questions?
No.
Okay. All right. I don't see any other questions.
Thank you.
okay,
Thank you for being here.
Yes, thank you.
Let's have our next proponent.
My name is Tessa Dominguez, TESSA-DOMINGUS. I attended the hearing of this bill when it was introduced last year. And one, I want to talk about one of the statements that was made during the opposition hearings of that bill. There was a prosecuting attorney that testified in opposition, and her statement was that allowing this bill to pass would be opening the floodgates. In my opinion, this gives us more than enough reason to take a look at this wording. The question is, how many Nebraska citizens are being held unjustly? A question that none of us can answer, but one that we should be seeking in order to right. Allowing this bill would protect the life and freedom of all Nebraska citizens from unjust practices. And I think it's something that we should be taking a closer look at. That's all I have.
All right. Are there any questions? All right, thank you for being here. Next proponent testifier.
My name is Jeff Pickens, Jeffpickens. I'm Chief Counsel with the Nebraska Commission on Public Advocacy. In 2000, Ernest Jackson was sentenced to life imprisonment without parole. In 2012, the Supreme Court in Miller versus Alabama held that life without parole for juvenile offenders is unconstitutional. I was then appointed to represent Mr. Jackson in his Miller claim. I represented him at resentencing and then on appeal therefrom. At one point, I knew his case probably better than anybody. It's been a while since I represented him. I'm here to testify on behalf of myself. I consider myself a friend of Ernest Jackson. I had an opportunity to get to know him very well, and I still talk with him at least a few times a year. What you heard about the facts of the case, I think I can try to summarize it maybe a little better. So these three men were charged with the murder. Mr. Jackson had the lowest case number. His case was filed first. Therefore, his case went to trial first. He wanted Mr. Cooper Ryder to testify for him, but Cooper Ryder refused. Jackson went to trial without Cooper Ryder's testimony. He was found guilty of murder, not guilty of using a weapon to commit murder. And then Cooper Ryder went to trial. He testified at his trial that he shot Mr. Perry. He did it in self-defense. There were two other people with him, but it was not Mr. Jackson nor Mr. Chillis. And he was found not guilty. Mr. Chillis went to trial next. Cooper Ryder testified on his behalf. He provided the same testimony. This is to another jury, a totally different jury. And that jury believed Mr. Cooper Ryder and found Mr. Chillis not guilty. It's not a stretch to claim that if Mr. Jackson had gone to trial after Cooper Ryder and Cooper Ryder testified on his behalf, he would have been found not guilty as well. His lawyer filed a motion for new trial after he was found guilty. And while that was pending, Mr. Cooper Ryder was found guilty, or rather found not guilty. So Mr. Jackson's lawyer filed a motion for new trial. That was denied. It went to the Supreme Court on the grounds that it was newly discovered evidence. The Supreme Court said, no, it's not newly discovered evidence. It's newly available evidence. And that's not a statutory ground for a motion for new trial. LB 18 fixes that problem. It provides a ground for a situation like Mr. Jackson's case where the evidence is not available at the time of trial, but it's available later. And I would urge you to support Legislative Bill 18.
All right, thank you very much. Are there questions from the committee?
Thank you.
I don't see it. Oh, Senator McKinney has one.
Thank you. Thank you for your testimony. What do you think happens when innocent individuals are sent to prison for years and are not given the ability to address their not given the ability to be released or speak to their freedom and why they should be free?
Not given a mechanism to get back into court.
Yeah,
That's a terrible injustice. And that's what happened to Mr. Jackson. He didn't have a mechanism to get back into court until the decision in Miller versus Alabama. But that only gave him an opportunity to get a new sentence, not to have a new trial.
thank you.
And I have a question for you. How many cases would you suspect, and maybe you're not the right person to ask this question, exist in let's say, first a year, where there are co-defendants in which this information, this evidence is not available and then later becomes available because of a later trial?
I think this is a very unique case. I don't think this happens very often, but I don't think that's a reason not to amend the law so that it will handle a situation where there is an injustice like in Mr. Jackson's case.
I'm more asking you, do you think this will lead to a bunch of post-conviction work?
No, I don't think it will. I can't imagine it's going to there will be many people moving for post-conviction relief based upon this amendment.
All right, thank you.
You're welcome.
Any other questions? I don't see any. Thank you. Next proponent testifier.
Good afternoon, Vice Chair DeBoer and members of the committee. My name is Spike Eichholt, S-P-I-K-E. Last name is E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorneys Association in support of LB 18. This bill has been introduced before. We have supported it. I don't really have much to add. I think Mr. Pickens gave a very good summary of what the bill does. I would like to highlight one important point about Mr. Jackson's case is that as Mr. Pickens mentioned, Mr. Jackson was charged with 2 crimes, first-degree murder and use of a firearm or use of a weapon to commit that murder. The jury found him not guilty of using a firearm to commit a murder. So you might be wondering, well, how was he found guilty of the murder then? Nebraska law, like many states, allows for someone to be found guilty under an aiding and abetting or accessory theory. So what that means is that the jury was instructed that they could find Mr. Jackson guilty of murder even if they did not believe he actually shot the person. And that's apparently what the jury did. That's important because Mr. Cooperrider went to trial later, says, I shot him and Jackson was not there. And that jury believed Mr. Cooperrider. One of the things that's sort of very unusual, and I would submit very unjust, is that Mr. Jackson is serving a sentence that was lowered to 60 to 80 years imprisonment. He's serving a sentence having been found guilty under an accessory theory. No one was found guilty of committing the principal offense to which he was convicted of helping, aid, and abet. That's sort of a legal, perhaps not impossibility, but it's a legal peculiarity. It's very unjust, one would suspect. What's even more unjust is that without LB 18 or similar law, Mr. Jackson does not have a way to sort of re-litigate this point or raise this legal issue. The issue of, am I being justly imprisoned under an aiding and abetting theory, serving a sentence when there was no one convicted as a principal offender? He can't do it in a post-conviction claim. He cannot do it in a motion for new trial. This does provide a very narrow exception to the 5-year prohibition, or really the absolute bar for bringing a motion for new trial for cases like him. To answer Senator DeBoer's question, I don't think it's going to come up that much. Even if there are circumstances where somebody has co-defendants and somebody does invoke the 5th, you still have to make the showing that whatever evidence you have is material to your guilt. It just can't be something that somehow happened and there's other evidence. In this case, this is material, and I ask the committee to advance it to the floor. And I'll answer any questions if anyone has any.
Any questions? I have a question for you. In felony murder, there has to be an underlying felony that is the whole group, right?
Right.
So what was the felony in this case that the whole group was participating in order to convict someone of felony murder?
I think the theory of the prosecution's case was that it was a felony robbery. There was some sort of argument, I think, if I remember right, between the state said between Mr. Cooperrider, Mr. Chillis, and Mr. Jackson and Larry Perry. And under a felony murder, just so the record's clear, you can be found guilty of first-degree murder if you intentionally and deliberately and with premeditation kill somebody. Another way you can be found guilty of first-degree murder and receive a life sentence, or even worse, if you intentionally commit a felony. There's about maybe 6 or 7 of felonies, and during the commission of that felony, someone is killed. Yesterday, a woman testified that I think her older brother is serving a life sentence for murder relating to a burglary, and it sounded to me like that was an example in which somebody committed a burglary by forcing their way into someone's home. The woman who lived in the home had a heart attack. That is a burglary. During the commission of that burglary, someone dies. That's a first-degree murder. Robbery is another underlying felony that can support a first-degree murder. Arson, and another, the law school example that happens in real life is somebody sets fire to a building, the fire department's on the way, and somebody gets injured, a fire person falls off the truck or something like that and dies. That's murder. So that's sort of, I think, the theory that this case may have done in this case. But what's notable is that the jury was instructed on an aiding and abetting theory, that you don't have to believe that Mr. Jackson was the actual principal offender of either the felony or the actual intentional murder to find him guilty.
So was Mr. Jackson convicted of any felony other than the felony murder?
Just the murder.
Okay, thank you. Any other questions for this testifier? Thank you. Next proponent testifier.
Good afternoon, Vice Chair DeBoer and members of the Judiciary Committee. My name is Jasmine Harris, JASMINEHARRIS. I'm the Director of Public Policy and Advocacy with RISE. We're the largest nonprofit organization here in Nebraska focused solely on habilitative programming in prisons and reentry support. And our mission is to break generational cycles of incarceration. The Innocence Project, which works to exonerate wrongfully convicted individuals through DNA testing, has estimated that about 1% of the U.S. prison population are wrongfully convicted. That is about 20,000 individuals. The Equal Justice Initiative has been providing legal services to people who have been wrongfully convicted and unfairly sentenced in prisons and jails in the United States since 1989. A lot of their exoneration cases have been based on wrongful conviction through false accusations made in court, government official and law enforcement misconduct, and false forensic science, among other leading causes. There have been over 3,175 exonerations since 1989 in the United States. RISE's vision is that all people will find freedom from cycles of incarceration. LB 18 would provide a way for Nebraskans who have been wrongfully convicted to appeal their case and submit new evidence to prove their innocence, therefore being freed from the cycle of incarceration where they are currently held captive. While working with incarcerated people in Nebraska, we have been able to interact with many individuals and have given them one of the things that they need the most, a listening ear. We've heard the story of Ernest Jackson, and I've heard Avery Tyler's name mentioned today as well. Both of these gentlemen have taken RISE, they've graduated, they've become peer facilitators, which means they go and then help other young men who go through this program as well. RISE is here to encourage all elected officials to look at this from the perspective of empathy. We must stand on the side of justice and what is right in order to facilitate the vision that all innocent people should be free. Even if one person is freed through this legislation, it is worth it. And so for these reasons, RISE supports LB 18 and asks that the committee members vote this bill out of committee to general file. Thank you.
All right. Are there any questions? Senator McKinney.
Thank you, Senator DeBoer. Ms. Harris, can you speak to the person that is Ernest? I've, since my time in the legislature, have on multiple occasions had an opportunity to talk to him on the phone, and then when I've visited the prison, I've sat down and talked with him a lot. And the last time I seen him, it was during a Kwanzaa celebration for Harambe that he was leading. He was one of the mentors, and he is a mentor inside, and he helps younger individuals inside get on the right track, as well as keeping himself on the right track. Can you speak to who he is as a person from what you've seen?
Yeah, I was able to go into the facilities at this point in time as our post-release program manager. And as our program stood, it's about 6 months, and individuals would work on character development and employment readiness, entrepreneurship skills, and present a business. So I was able to watch as we went in for business coaching days and listen to his personal statements, what growth he's gone through in the time that he's been incarcerated. He's actually was one of the winners of our business coaching day, and his business was one of those top businesses. So to say who he is now compared to who he was then, I wouldn't be able to say that. But I know that as being in our program and being a peer facilitator for our program, he has done a lot of work to help individuals, and I know people look up to him in that facility.
Thank you. And I wanted to highlight that because I wanted to show that considering the situation he's in and has been in, he's still working to improve himself and others around him and trying to be a leader as best as possible. And it also speaks to the bigger topic of individuals that do serve that amount of time, they do change, and they don't stay the same. They might go in young, but as time progresses, they mature into men and women that deserve a second chance. And in Ernest's case, he deserves a chance to be, he deserves justice.
Yes.
Thank you.
Thank you.
Yes.
Any other questions? I don't see any. Thank you so much for being here. Next proponent testifier.
Good afternoon, members of the Judiciary Committee and fellow Nebraskans watching online. My name is Alex M. Houchin. That's A-L-E-X. M as in Michael, H-O-U-C-H-I-N. I'm speaking today not just for myself, but also on behalf of Nebraskans for Alternatives to the Death Penalty. We're an organization dedicated to reducing and eliminating the state's legal authority to kill its own people. Both the U.S. Constitution and the Nebraska State Constitution guarantee that once you're accused of a crime, whether or not you actually did it, you have the right to a fair trial. This includes not just the right to effective defense, but also the right to present any and all evidence or testimony that may exonerate you of that crime. This is true whether you committed the crime or not, but it's especially important when you're innocent, because although we all want to believe otherwise, we know that our system can and does convict people for crimes they didn't commit. Sometimes we lock away these people for a long time. Sometimes we kill them. That's years and lives taken away unjustly, stolen by the state. Of course, there are safeguards designed to prevent these outcomes, but these safeguards can always be improved. Currently, Nebraska Revised Statute 29-2101 states that if you're convicted of an offense, you can motion for a new trial for a number of reasons, including newly discovered evidence. LB 18 would make a small expansion to the definition of newly discovered evidence to include exonerating or mitigating testimony or evidence that was not produced in your trial because someone else invoked the self-incrimination clause in their trial. It also eliminates the time limitation for seeking a new trial following conviction for the most serious crimes that carry the most severe punishments up to and including death sentences, because there should not be an arbitrary time limit on preventing executions of innocent people. Senators, this bill closes loopholes in the law that allows our justice system to continue punishing innocent people in our names, which is the last thing it's supposed to do. Please vote LB 18 out to general file, and please support it all the way to final passage. Let's make our system a little bit more just. That's something we should all want. Thanks very much, and I'll try to answer any questions you might have.
Are there any questions for this testifier? I don't see any, but thank you for being here. Next proponent testifier.
Hi, my name's Judy King, Judyking, and I'm in support of LB 18. Ernest Jackson is innocent, and he's been in jail for over 20 years, and nobody's doing anything about it. This will do something about it, about someone who's innocent that has been in prison for over 20 years. I would like to see some of you on the legislature go to a prison and spend the evening in the jail for a day and see what it's like just one day to be in prison and see how it might change your empathy on some of these things. He's innocent and he's been in there for 20 years. Another thing that is disgusting is the Pardons Board, who is run by Ricketts, let a sexual assault, first-degree sexual assault person free. But But an actual innocent person, he didn't do anything about. He opposed that all the way, and along with the pardons board. You need to change the pardons board and give them the information on this gentleman so that the next time somebody's wrongly arrested and put in prison for 20 years, maybe they might have the information to release that person instead of making it political. They let out a man that court records indicate he broke into an Ogallala home of his estranged wife, then terrorized her with a knife. He tied her to a bed and sexually assaulted her while in front of their children, 5 and 7, were in the home. This gentleman then took the children and fled to Texas, leaving his wife bound and gagged. This is someone that Ricketts pardoned. But an innocent man, he didn't. Isn't that odd? He did it because there were a bunch of gentlemen with Legion hats on in the front row. And after talking to a former state Legion commander that lived in Scottsbluff, her name was Beth Lynn, who served as a state Legion commander from 2016 to 17, also said that while this gentleman has claimed the sexual assault was a misunderstanding, she said it was far from it. And Ricketts let that person on parole. I really thank Senator Wayne for bringing this forward. I sat through that same thing where I listened to that there was going to be an overflow of people. I got it. Thank you.
Thank you, Ms. King.
Thank you, Senator Wayne. We really appreciate this.
Let's see if there's any questions for you. Anybody have any questions for this testifier? I don't see any. Thank you.
Yeah.
Next proponent. Are there any other proponents?
Hello, I'm Tracy Jackson, TRACYJACKSON. I'm Ernest Jackson's wife. I want to apologize in advance, I'll probably cry. So everybody spoke about LB 18 and how it'll affect him, but I'm going to tell you about Ernest Jackson. Ernest Jackson is a man that went to prison at the age of 17. It wasn't easy. He had trials and tribulations, obviously, as a 17-year-old, but going into a grown man's prison. He had a lot of write-ups. But let me tell you about the man he is today. He's employed, he's educated, he's a mentor, he's a leader. He's the one in the prison that breaks gang fights up or eliminates the fact of that situation even happening. That's the man that Ernest Jackson is. He deserves a second chance, and this bill would do that. There are several other states that maintain post-conviction laws and statutes and case laws similar to LB 18. These states are comprised of red and blue, so it's a bipartisan. LB 18 allows for juries to hear all the evidence and will allow for more accurate outcomes. Let me ask you all a question. In a system that claims to seek what is right, whether the truth should be unseen in courts, because that's what we have today. That's what we have 22, almost 23 years ago. Ernest Jackson has been incarcerated for almost 23 years for a crime that somebody else admitted to, was acquitted on, and also got the other co-defendant acquitted. So legitimately, he drew the short end of the stick. How would you guys like to pull in a bag and pull the short end of the stick? Just because that's what the wording is and that's what the judge understands or what he interpreted of newly discovered evidence. So that's my question to the panel.
Are there any questions for this testifier? Senator McKinney?
Thank you, Senator Gore, and Ms. Jackson, thank you for your testimony. I also wanted to highlight something else. Yesterday, Senator Blood when we were talking about terminal illness and medical parole, and about the young man that lost his life due to an illness. It was Ernest that directed the department to help that young man. And if it wasn't for Ernest, that young man probably would have just died in his cell.
Correct, yeah, he was his roommate, and he insisted staff several times, this man needs medical attention. There's something wrong with him. Like, it's not normal for a 20-some-year-old man to be slurring his words. So yeah, absolutely. And that's just in general the man that he is. He wants to help everybody, and that's what he's gonna do to his community if you pass this bill and give him a chance for another retrial. So
Thank you.
Thank you. Thank you, Senator McKinney. Any other? I don't see any. Next proponent testifier.
I'd really love to have Ms. Jackson have the last word, but I'm here anyway. Thank you, Judiciary Committee, for hearing this very important bill. My name is Laureen Ludy, Lorene Ludy, and I'm speaking for myself and also as a volunteer for the Alternatives to Violence Project. This is a project that was started in 1975 in Greenhaven Prison in New York to reduce violence in prisons. Part of our model is to have a team of facilitators that we call insiders and outsiders. So some people come in from the outside and some of the facilitators are inmates. Ernest Jackson became a facilitator in this program in 2019. I've been working with him closely since then, and in the last year, I've seen him probably every Saturday, almost every Saturday, 2022. So I feel like I know him in a professional status as a team member. One of the homework in the Alternatives to Violence Project is to do an act of kindness, because kindness is the opposite of violence. People who are kind are not violent. Ernest Jackson is kind. He's compassionate. He's sensitive. He's empathetic. I serve on a team with him. I trust him. I would be happy to have him as my neighbor, to marry my daughter, if you weren't already married and I had a daughter. He's a decent human being. I was heartbroken when the Pardons Board dismissed his case without listening to any testimony from anybody. I am on the board of my homeowners association, and I often hear people bring issues or concerns or complaints about things that I can do nothing about with my power and authority on the board. But every once in a while, there's something I can do something about, and there's a great satisfaction to be able to do something that helps my neighbor, that makes their life better. You are in this unique place to do something to make Ernest Jackson's life better. It's you. It's not the Pardons Board. We know that they kind of didn't step up to do that. But this Justice for Ernest Jackson bill, which is that's not what it's called, but we all know that's what it is. You're in the position to take a step to improve the life of a concrete person who deserves to have his life improved. Are there any questions? Thank you for listening to my testimony.
Thank you. Are there any questions for this testifier? Thank you very much for being here. Are there any other proponent testifiers? Welcome.
Good afternoon, Vice Chair DeBoer and members of the Judiciary Committee. My name is Jaden Perkins, and I am Heartland Workers Center's North Omaha community organizer. At Heartland Workers Center, we believe in policies that seek to tackle the gross mishandling of justice in Nebraska's criminal legal system, and LB 18 supports that mission. Due to the mass incarceration policies in Nebraska and the United States as a whole, Black, brown, and indigenous people are overrepresented in the system 6-1. If given a chance at a later trial, I bet a good number of them would be found innocent. Last year, there was a lot of consensus around this bill, and it failed by just a few votes. Urging you all to strongly consider, along with your colleagues, to pass this bill once and for all, as it is a common sense measure that will give people a true chance at freedom. Free Ernest Jackson and free any and all innocent Nebraskans who have been affected by our racist criminal legal system. Thank you.
Thank you. Sir, could you spell your name? We didn't get your spelling.
Jadenperkins.
Thank you. Are there any questions for this testifier? I don't see any, but thank you for being here. Next, proponent testifier. Are there any other proponents? Welcome.
Thank you. Good afternoon, Senators. My name is Dr. Sarah Sawn Thomas, SARAH-SAWIN-THOMAS. I'm here representing both myself and Stand In for Nebraska, which is a 501c3 human rights and justice organization in Nebraska. We advocate for and alongside multi-marginalized Nebraskans. This case is one of the most important, and I hope you feel that way as well. As a white person with resources who's benefited from my privileges and my family in Nebraska, I am stunned really by, why would there be such an omission in legislation, that you could be convicted falsely and not be able to bring new evidence to exonerate yourself. And I guess it doesn't seem too surprising to me because white people with resources who craft policy tend to have blind spots, forgive the ableist language, tend to have omissions. It's interesting when white people get really mobilized by policy, usually there's some direct impact that they personally, empathetically experience, and I think that's very sad. What's amazing to me is the ability to work alongside mostly 20 women who have radically different lives than mine. I see how the nuances of policy, and this is one, this nuanced omission in policy devastates so many Nebraskans. I'm grateful for the Innocence Project. I'm grateful for advocates like Jasmine Harris. I'm grateful for Jaden Perkins, who bring this research-based information to light. And I was part of the pardons, that whole experience, which was horrifying, to be honest. It's sick, it made me sick to see a free man ignored, disregarded, dehumanized. But white people with resources who do violence with those resources lack empathy, lack conscience. And I sure hope this committee is not comprised of such folks with power and influence. I'm open for questions.
Are there any questions for this testifier? I don't see any, but thank you for being here.
You're welcome.
Next, proponent testifier. Are there any other proponent testifiers? We'll switch now to opponent testimony. Is there anyone here to testify in opposition to this bill? welcome.
Welcome. Oh, thank you. Good to be here. Good afternoon, Vice Chair DeBoer and members of the Judiciary Committee. My name is Mike Guinan, Mikeguinan. I'm the Criminal Bureau Chief for the Nebraska Attorney General's Office. I appear here before you today on behalf of Attorney General Mike Hilgers and the Nebraska Attorney General's Office in opposition to LB 18. We are opposed to this bill as it purports to provide a post-conviction remedy to a single individual, which is not warranted given the facts and circumstances of that particular case. The basic facts were that Mr. Jackson went to trial first, and he defended on the theory that he was not present at the scene of the shooting. And that his co-defendant, Mr. Cooperrider, would not testify in his case given Mr. Cooperrider's assertion of his Fifth Amendment right to not incriminate himself. Subsequently, Mr. Cooperrider went to trial and defended on the theory of self-defense and was acquitted. Mr. Jackson asked for a new trial, saying that this was newly discovered evidence now that Mr. Cooperrider testified in his own trial. The trial court denied the motion, stating that this was not newly discovered evidence, but instead newly available evidence. This holding has been criticized as unjust, and LB 18 is purported to address this unjustness for Mr. Jackson. However, because the trial court actually conducted the very inquiry that this bill seeks to implement, and because the results were not unfounded, this post-conviction remedy created for this single individual is not warranted. As noted by the Nebraska Supreme Court in a well-reasoned opinion, such a remedy would encourage perjury when the second acquitted defendant were invited to testify in a retrial of the first case. Quote, such testimony would be untrustworthy and should not be encouraged. As such, the Nebraska Attorney General's Office respectfully asks the members of this committee to not advance LB 18 to general file. Thank you, and I'd be happy to answer questions at this time.
Are there questions for this test? Senator Blood.
Thank you, Vice Chair DeBoer. Can you please read that sentence again right before your closing? What was the sentence that you said?
The Supreme Court, what they said? Is that what?
Yes.
Okay. They said, quote, such testimony would be untrustworthy and should not be encouraged.
Can you clarify that for me? I'm not understanding why it would be untrustworthy.
Sure. What they were talking about in the opinion at that point was if Mr. Cooperrider is acquitted in his case, correct? And then he comes in and testifies in a retrial on the first case, he could say whatever he wants. He can't be tried again. He can't be put in jeopardy again.
So that makes him untrustworthy?
It may. It could invite untrustworthy testimony, yes.
Is that the norm? Would you say, or are you just saying this is one court's opinion?
Well, that's their quote, right? And they were following case law from other jurisdictions where other courts have found to the same effect.
Okay, so clearly I'm not a lawyer, so I like to get things right in my head.
Sure.
So that's why I'm asking additional questions.
Sure.
So I guess the question that I have is, in Nebraska, is that the norm? So if you two people are charged with a crime and one person is acquitted, that person generally is never invited to go and testify in the other trial. We just don't do that because we don't trust that they'll tell the truth.
Will they be invited to testify?
If they indeed were invited to testify in the person who is still standing trial.
They could be, sure.
They could still testify.
Sure.
So not everybody will find it untrustworthy. It's really based on a court's opinion in that case.
Right.
Okay, thank you very much.
Yeah.
Other, Senator McKinney.
Thank you, Senator DeBoer. So 2 jury trials found they found the testimony to be trustworthy because if not, one wouldn't have got found not guilty because of self-defense and the other one wouldn't have got off. But my question is, isn't trustworthy Isn't trustworthiness and credibility issues for a jury to decide, not a judge?
Sure, the fact finder makes those findings, yes.
And if they lie on the stand, you could charge them with perjury, right?
Could charge them with perjury, correct.
All right, thank you.
Mhm.
Any other questions? I have a couple for you.
Sure.
So on the Supreme Court's theory that someone who has been acquitted would be potentially somewhat induced to lie. Okay, then you have the perjury question. In addition, wouldn't that happen every time there were multiple defendants if the order were just different? So if Mr. Jackson's case had been second after Mr. Cooper Ryder's, would Mr. Cooper Ryder, then having been acquitted, not have the same inducement to false testimony as he would if there were another trial later?
Well, so I guess maybe to answer your question, I could walk through kind of factually, I think, my understanding of reading the case.
Okay,
And hopefully, if I don't answer your question, let me know.
yeah,
We have the factual scenario, right, where the first individual went to trial.
yeah,
He requested the second individual to testify. He claimed the fifth, and the first individual was convicted. The second individual goes to trial in his own case, and he goes, two things that came out in that trial, Mr. Cooper Ryder's. One, he had a self-defense claim. And two, he said that Mr. Jackson was not present at that scene. So when Mr. Jackson now is asking for a retrial on that, he's saying, well, I'm asking for a retrial. Now, he can do that on one of two theories. His whole first trial was, I wasn't there, right? So he probably is not going to go on the theory on the second trial that I was there and that guy had a self-defense claim. Because in his own first trial, even though Mr. Cooper Ryder, if he was there.
but I guess my question is this: if the Supreme Court's concern is about setting up the circumstances for someone to perjure themselves, aren't those circumstances already in place if you have multiple defendants and the primary defendant gets acquitted and then could come and speak because he no longer has a Fifth Amendment concern in all of the other cases, as we saw with, and I'm sorry, I can't remember the name of the third co-defendant's trial.
Chihuly or something.
In the third co-defendant's trial. So wouldn't the possibility of perjury in the third co-defendant's trial be the same as what it would be in a new trial for Mr. Jackson?
That is a possibility, yes.
Okay. And what was the are you familiar with, I don't know how familiar you are with the case.
Only what I've read in the opinions.
Okay. So do you know what the underlying felony was that the felony murder theory was based on?
I'm not aware that it was a felony murder. I just understood it to be first degree, and I thought it was an aiding and abetting theory to first degree murder.
Okay. Can you distinguish those for me? It's been a while.
Sure. So first degree murder is killing somebody intentionally.
Sure.
With premeditation.
Yeah.
So I can aid and abet you if you kill somebody intentionally by either actively being involved or if I encourage you to kill somebody.
So it wasn't felony murder that he was being charged on?
Not that I'm not familiar
Okay.
with that. I thought it was aiding and abetting just a straight first degree murder.
Okay, I had a misapprehension. Sorry about that.
That's
All right. So that helps clear up at least that piece for me. I think that's it that I have for you. Are there, Senator McKinney?
Can you explain how is it possible to aid and abet someone that is found not guilty of the crime that you're saying they aided and abetted? That's the elephant in the room here is, how is that possible?
Right. So if Mr. Jackson said he was not present at the first, if let's say he says he was present at the first scene, right? So he was there. Let's just say that was the fact. And Mr. Cooper Ryder shot our victim in self-defense. if Mr. Cooper Ryder says, I don't want to testify in your case, it's a Fifth Amendment privilege, I don't want to testify, that doesn't prevent Mr. Jackson from asserting that same defense, right? Because as an aider and abetter, I'm stepping into his shoes. So if I say he doesn't want to testify, but I still put on a defense that he acted in self-defense, you're right. I can't be I can put that defense on because I can't be an aider and abetter to a non-crime, a self-defense. So he wasn't prevented from putting that defense on. I think the point is he said he wasn't there at all. So I think my assumption is what he wanted a second trial on is Mr. Cooper Ryder said in his trial that Mr. Jackson was not present. I believe that that's probably the theory.
I guess my last question, and you could just say yes or no. Do you not see where there was an injustice that took place? Yes or no?
I don't. I'd like to finish that thought.
No. Thank you.
Are there other questions? Let me ask you this.
Sure.
I think what I heard you just say was that Mr. Jackson wants to switch theories of the case from one theory of the case, which is I wasn't there, to a theory of the case, which was it was self-defense. Is that what I just heard you say?
I'm saying if in the second trial that he's asking for, he puts on one of two defenses, right? But if he says now I was there and that guy shot in self-defense, that would be a new theory because in his original trial he said I wasn't there.
Isn't that even more of newly discovered evidence then that he's discovering that? I mean, that's actually discovered that it was self-defense. Maybe he didn't know it was self-defense in the first case. That's not for us to argue, but
yeah,
that might be even more so
but
discovered because so going back to law school, because it's been a while, if someone kills someone in self-defense, has a crime been committed?
Has a crime, they are.
Just a random person. If I randomly kill, Anjanita in self-defense,
Yes.
has a crime been committed?
It is a crime until the jury finds that you have, or you are not guilty because you had affirmative defense of self-defense.
Okay, so
Right.
when my affirmative offense is confirmed by a jury,
Right.
then a crime has no longer been committed.
Yeah, effectively.
I mean, okay.
So if to kind of, I guess, finish that out, right? Here's, in that case, right? So in the second trial, let's say he's asking for a second trial. And let me change one fact. All the same facts except Mr. Cooper Ryder is actually found guilty in the second trial. In his trial, I'm sorry. And Mr. Jackson says, I still want a new trial, right? Because it's now newly available, newly discovered, because the person who the first time around said, I'm not testifying, but now he has testified. So he says, I want a new trial. So the question is, should he get a new trial?
That's an interesting point.
And if, and just to finish that thought out, what the appellate court actually states on that, I'll read you exactly what the appellate court said. So Jackson filed a motion for a new trial alleging that Cooper Ryder's testimony from Cooper Ryder's and Chillis's trials provided new evidence that would have changed the jury's verdict in Jackson's trial. The district court overruled Jackson's motion for a new trial, finding that Cooper Ryder's testimony was not newly discovered, but newly available. Cooper Ryder merely controlled the dissemination of his testimony for tactical reasons. That's what's being complained about. The very next two sentences that the court cites is, in its order, the district court referred to telephone conversations in which Cooper Ryder discussed coordinating his testimony with Chillis and other witnesses testifying in Chillis's trial. The district court concluded that even if Cooper Ryder's testimony had been presented at Jackson's trial, the jury still heard enough evidence to convict Jackson. In other words, the district court actually conducted the very analysis and said, this is, it's not newly discovered, but I conducted an analysis. I sat through the trial. It was however long, a 12-member jury who listened to all the testimony, including, which I think is rather important, alibi testimony, which was Mr. Jackson's aunt and cousin said he was over at their house from before the shooting through the shooting.
So then I'm still kind of hung up on the available discovered piece.
Sure.
If I'm a smart co-defendant, then do I just not ask anybody to testify in my trial so that once they testify in another trial, I can say, oh, I never knew about that. Now it's newly discovered.
Sure, why not?
Well, that doesn't seem like a good idea, but that's not a question. I will.
That's a problem, isn't it? I mean, if you can just sit back and then you get a new trial.
Well, that's the law now, right? So, okay, are there other questions for this testifier?
One,
Senator Decay.
real quick, I don't understand law very well.
Sure.
Or at all, but I am asking if, say in a first trial, the defendant said that he wasn't there. And and wanting a second trial, finds out that it was in self-defense, he was there, but it was self-defense. Is there any grounds for perjury in that because it's two different testimonies where you were at the time of the incident?
Are you talking the second individual that claimed self-defense?
No, if.
The first guy?
Yeah.
Okay, so in the first case, he
says he
was there.
Said he wasn't there.
Wasn't there.
And in the second instance, he said he was there, but it was the guy that admitted to self-defense. And he said, well, I was there, it was self-defense. What's the course of action with that?
Could he be charged with perjury?
Well, I'm just wondering if there is any, because it seems like a different testimony for a different trial for the same incident.
If he testified in the first trial, which I don't think Mr. Jackson did, if I understand.
Okay.
He didn't testify. They just had a defense of he wasn't there. That was my understanding.
Okay.
But if he did testify and he gave false statements
I wasn't there for the trial or, know a lot about it. I didn't know if or not Mr. Jackson testified in his own behalf or not in the first trial. So that's why I was asking.
Yeah, my understanding from reading the cases, he did not.
Okay, thank you.
Yeah.
Are there other questions? Thank you so much.
Yep, thank you.
Next, opponent testifier. Welcome.
Good afternoon, members of the committee. My name is Don Klein, K-L-E-I-N-E. I'm the Douglas County Attorney. I'm here as the Douglas County Attorney and as a representative of the Nebraska County Attorney Association to oppose LB 18. Just a little bit of background. I've tried probably over 50 first-degree murder cases. In fact, I also was a defense attorney and tried many cases as a defense counsel and won 2 murder trials, one based on a self-defense defense as a defense counsel. In this case, Mr. Jackson was represented by competent counsel. That's never been an issue. He chose not to testify in his own defense. There were eyewitnesses who testified he was there and he participated in the killing of Mr. Perry during this incident. He decided not to testify on his own behalf. The judge heard all the evidence in the case, heard a motion for a new trial. He was sentenced. This case has been up to the Nebraska Supreme Court twice. Okay. And it was also sent back to the original judge for sentencing under Miller versus Alabama. Our office handled that. We said, go ahead and put all the evidence in that you want to about the innocence or that he wasn't there or whatever it is. So defense counsel was able to do that. The judge still sentenced Ernest Jackson to what he was sentenced to. Then there was the Supreme Court again, and then it was heard by the Pardons Board. There's been a lot of review of this particular case. So I have a hard time when I hear people say that Mr. Jackson's totally innocent in this thing. He didn't have any participation in this. You know, there are a lot of times when co-defendants make decisions about cases, and one of them decides, I'm going to go with a self-defense defense, and the other one says, I'm going to go on something else, and one gets acquitted and one gets found guilty. And that happens. And when our Supreme Court looked at this, and our Supreme Court has justices on there a lot smarter than me regarding the law, they were very clear that this policy would encourage perjury to allow a new trial once co-defendants have determined that testifying is no longer harmful to themselves. They may say whatever they think that it might help their co-defendant, even to the point of pinning the guilt on themselves, knowing they are safe from retrial. Such testimony would be untrustworthy and should not be encouraged. And then they cite a multiplicity of other states that agree with that statement or that regard. So they don't just say, hey, we don't have the statutory authority to do this. They say, hey, this is not a good idea to do this at all anyway. And I'm sorry if my time's up. I'd be happy to answer any questions. So I'm in opposition to this bill, obviously, and the county attorneys are.
Senator McKinney.
Thank you. Thank you, Mr. Klein. How many times in your experience as a prosecutor have you seen a case where multiple individuals are accused of murder, one admits to it, but is found not guilty by way of self-defense, and also in the trial says that the other person wasn't there, that another person ends up going to jail for that crime?
I don't know if I've ever seen that come about, where they said the other person wasn't there after the fact. So I'm aware of who Mr. Cooperrider is and his background. And
yeah, but all right, I ain't gonna go all day. If this bill passes, would your office oppose Mr. Jackson's motion for a new trial?
Well, sure.
You would?
Well, that would be standard. We think he had a fair trial first time through.
All right, well, my real last question. In your experience, in your time in the DA's office, do you think every case you tried was fair and justified in outcomes? Every case, everything was perfect?
Sure, they're all not perfect. Sometimes I think that maybe there's more evidence that we could have put in and we weren't able to get it because we found out about it later. Sometimes I think that maybe I question the strategy of counsel on the other side.
So you never sent an innocent. So it's your belief you've never sent an innocent individual to prison?
Absolutely, never.
All right, thank you.
Sure.
Other questions? Okay, I wanted to ask a clarifying question. You said that it sometimes happens that there are co-defendants where one claims self-defense and another claims maybe they weren't there, something like that.
Well, and there could be a number of defenses, somebody might say, with co-defendants. It doesn't necessarily have to be self-defense. They might say they weren't there. They might have an alibi, whatever it might be. But there are certain times that one person might be convicted and another person is not convicted, is what I'm saying.
But the self-defense one is interesting to me because I wanted to just kind of play with that one for a second, because self-defense kind of nullifies the crime existence, right? If you do
well, it's
something.
still a homicide that takes place.
It's still a homicide, but it's not a murder.
That's because the jury found in that, and I think as a defense attorney, the best defense to have is self-defense. Because the way the self-defense instruction reads is that you have to be in fear for your life or someone else's, and that you have a reasonable belief about that. And the jury instruction says, even if you're wrong about that belief, if it was reasonable, then self-defense is a legitimate defense there.
But once that self-defense, affirmative defense is found by a trier of fact to have been they say, yes, we agree with that, it was self-defense, then that nullifies the existence of a crime because it is not a crime to act in self-defense. Am I getting that right?
Right, for that person. That's not what the eyewitnesses said that testified at trial in Mr. Jackson's trial.
Sure, but right now I'm going with the theory. Like, the idea of self-defense is that the crime didn't exist.
No, it's not the crime that there is, it's the person was justified.
You're right, justified. But then if you're justified, then there is no crime, right? Because if I do something with a affirmative defense that justifies my actions, then I have not committed a crime. Is that right?
Well, the jury says you're not culpable because you were legitimately defending yourself.
So it goes to the intent?
Sure, it goes to all those things, what's going on in your head, what you thought this person was doing, those kinds of things. And that applies to that individual who's asserting that defense.
But if I had a case where I had co-defendants, for some reason they were being tried together, I don't even know if that's even possible.
It's possible.
Okay, and I have co-defendants who are being tried together and you find out that it's self-defense, doesn't that automatically, for that trial where they're being tried together, wouldn't that automatically make the other person also not guilty?
Well, that's one of the issues about trying people together.
Yeah.
Because that if one defendant says, this is my defense, the other defendant says, this is my defense, then you don't have a joint trial with those two defendants.
But sure, but let's say they both say, I pulled the trigger, Senator Blood happened to be along, and both of us are going to say, we were not guilty because I acted in self-defense. And if the jury finds that I acted in self-defense, her defense is that I acted in self-defense, then it would apply to both of us.
Right. I understand under those fact situations, but if you know the fact situation on this case, Mr. Perry was shot many times.
Mm-hmm.
Okay. And there's testimony that was multiple different guns that were used. So that probably had an influence also on the jury the first time.
Mm-hmm.
Okay.
It's the thing that always bothers me about this one is that I wonder if the order had been different, if things would have been different. If Mr. Jackson had been tried third, let's say, would there have been a difference? And if it's only the order that led to the outcome that it did.
No, it's not the order, it's the evidence. But that jury heard the evidence in that case and found him guilty.
So
But then they didn't know what the order was or what it was going to be.
Right, but what I'm saying is because the evidence was limited based on the order that they were tried in, there was limited evidence, i.e. the evidence from Mr. Cooper Ryder was not available. So the order mattered, right?
Well, but I don't know if anybody knew what Mr. Cooper Ryder would say at the time Mr. Jackson went to trial.
Yeah, okay, so then it was kind of newly discovered because they didn't know what he was going to say.
I don't know if Mr. Cooper Ryder knew what he was going to say at that time.
Yeah, and it particularly would have to do with his intent. Then it was discovered because his intent was not discovered until he articulated it in that trial.
And that's probably what the Supreme Court's saying, that once he figures out that I can't be in trouble anymore, I can say whatever I want to say about everybody else.
Wouldn't that be true in any circumstance where the primary suspect is tried first and then the accessories are tried second and third?
Well, it's not even in necessarily just these cases. We have cases pending right now in a post-conviction matter where we convict somebody in a jury trial and somebody who's already in the penitentiary doing life says,
Pin it
I
on
did
me,
it.
yeah, okay.
Pin it on me.
So
there's multiple situations where this can happen, and that's part of the issue.
Okay.
Okay.
Are there other questions for this testifier, Senator Geist?
And that part is what you're trying to trying to keep what the situation you just said from happening is what you're trying to prevent in opposing this, correct?
Yeah, and it's no. I would do everything I could to make sure that we don't convict somebody who's innocent, okay? And we do that. We review all of our cases. There's a process that took place in this case. The Supreme Court of our state looked at this a couple times. There was a board of pardons that looked at it. A judge resentenced this individual after knowing all this other evidence existed, okay? Or that there are allegations about this evidence. So there are safeguards within the system. There are 7 ways in a post-conviction action that a person can attack their conviction besides their direct appeal that they can take to the Supreme Court immediately. But what we don't want is to have the morass of people coming in because they're not in jeopardy anymore, or they have there's no issue, and that's why their credibility is suspect according to our Supreme Court.
Thank you.
Okay.
Other questions? I don't see any. Thank you.
Thank you.
Let's have the next opponent testifier. Next opponent. Is there anyone here to testify in the neutral capacity? Anyone neutral? For the record, we have 40 letters of support, and since Senator Wayne has waived closing, with that, we will close our hearing on LB 18 and open up our hearing on LB 19. And we understand that Senator Wayne's LA Jake will be introducing LB 19 today. So we will ask him all the difficult questions.
Yeah. Sure. Thank you, Vice Chair DeBoer, members of the Judiciary Committee. My name is Jake Seaman, J-A-K-E S-E-E-M-A-N, and I'm Senator Wayne's legislative aide. He wanted to be here today, but had a hearing this afternoon in Omaha I needed to attend. He represents Legislative District 13, encompassing North Omaha and Northeast Douglas County. I'm here on his behalf to introduce LB 19, which would take the cash value thresholds of crimes in the state and double them. It's been almost a decade since this has been adjusted in Nebraska, and Senator Wayne believes it's time for an update. It's important to manage the values necessary to trigger certain levels of crimes to keep up with the modern cost of things. And for legislators to make sure that inflation rates don't make our criminal justice system any more harsh than it rightfully should be. Thanks to inflation, which was 5% in 2021, 7% last year, we are nearing the point where a person can easily become a felon for stealing a cell phone. Right now, some versions of the iPhone 13 are retailing for more than $1,200. Tack on a fancy case or some fancy accessory and they're a felon now. There is no doubt that stealing is wrong, but those who caught should be punished, but the punishment should fit the crime. Other states have gone forward with this as well. Texas and Wisconsin have $2,500 felony thresholds. Alaska passed a law that required the legislature to evaluate and adjust their own cash value felony thresholds every 5 years. As in other states, this change will also prevent further and unnecessary strain on Nebraska's already stretched thin judicial and correctional resources, and will allow the state to prioritize costly, finite prison space for more serious offenders. Despite what opposition may say, there is ample evidence to conclude that felony thresholds set by the state have no impact on actual crime, as is the case with government guardrails like this. They weigh very little on the mind of someone moments before they steal a cell phone or a bike. The numbers are clear. This has no bearing on the actual total rate of crime nor the average value of thefts. Senator Wayne is open to collaboration and friendly amendments to help get this bill over the finish line and to make sure that our value-based penalties are regularly taking inflation into account. Vice Chair DeBoer, members of the committee, thank you for your time.
Thank you. We don't typically ask questions.
Well, you said we were going to ask.
I
you a
was
question.
more
Were you
joking.
being
Sorry.
No, that's
Senator
fine.
Geist, I'm sure there will be others to ask questions.
I will ask someone else.
First proponent testifier.
Good afternoon, Vice Chair DeBoer and members of the committee. My name is Spike Eichholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the Nebraska Criminal Defense Attorney Association in support of LB 19. what Mr. Seaman explained earlier is accurate about the bill. It adjusts the dollar value or dollar demarcations that determine the level of penalty for various theft, criminal mischief, arson, and other types of offenses. Our criminal code lays out a number of different crimes, and mostly in chapter 28-500 block that basically says what the penalty level is if you commit a certain crime. So the most common one that I think we'll be talking about today is the theft offenses. There's different ways you can be charged with theft. It can be theft by unlawful taking, it can be theft by shoplifting, theft by deception, and other different theories. And if you steal something or take something of value, even if it's got no dollar value, it's generally a class 2 misdemeanor. And I think the dollar value now is $0 to $500. That's class 2 misdemeanor, 0 to 6 months up to $1,000 fine. If you steal something that's got, say, more than $1,000 or more than $1,500 now in Nebraska, it's a felony. It depends on a little bit what type of felony is, either class 3 or class 4 felony. You don't have to necessarily know what the value is when you steal it. And the example that happens sometimes is somebody will grab a package off the porch, take it home, not realize what it is, and it turns out to be a fancy computer device, something like that, and oh my gosh, and they catch what it is, it's a felony. Or it could be just an insignificant clothing item, something like that. Doesn't matter. The penalty level is assessed, if you will, after you're sort of found guilty of the underlying crime. What this bill does is it adjusts the dollar amounts to adjust for inflation. For class 2 misdemeanors, the dollar amount goes from $500 to $1,000, and for the most part, it doubles, although there's some changing depending on what the actual crime is. We support this because, as Mr. Seaman explained before, some of these dollar amounts have not been changed at all since even before 2015. LB 605, the legislature did in 2015, did make some dollar adjustments to accommodate for inflation, but inflation has increased significantly. Other states have a similar value. So we would encourage the legislature or the committee to consider this change. You may hear from the retailers about shoplifting. I would just tell you that we have an enhanced theft, an enhancement to our theft crimes, which if you have 1 or 2 prior theft convictions, and they can be theft by unlawful taking, theft by shoplifting, you can be charged with a more serious crime. And in the theft, we have a 3 strikes law. So if you have a 3rd offense shoplifting, it is a felony. It's a class 4 felony. That won't be impacted at all with this bill. This simply changes the dollar amounts for the instant crime that the person is convicted of. And I'll answer any questions if anyone has any.
Are there any questions from the committee? We'll start with Senator Blood.
Thank you, Vice Chair DeVore. Can you say, in reference to the enhancement to the shoplifting again, when you would turn your head that way, I couldn't hear you.
Sorry. Well, I try to do that, but I can't talk about it. So we have some crimes are enhanceable. For instance, protection order, a second offense protection order is a more serious crime than a first offense protection order. You have to be convicted of the first offense before you can be charged with the second offense or a 3rd or subsequent offense. DUIs are enhanceable. Theft by shoplifting and other theft offenses is enhanceable as well. So if you have a theft by shoplifting prior, it can just be a candy bar. You get caught, you go to court, you get a fine, that's a conviction. 6 months later, you get caught again stealing from another quick shop, another convenience store, and this happens a lot. All this state with marginal people who are living on the edge of homelessness. This is a regular occurrence. They can accumulate a number of insignificant theft by shoplift convictions. A 3rd offense shoplift is a class 4 felony in Nebraska, and it does not matter what the value of the item is on the 3rd offense. It doesn't make any difference. It can be $0, it can be less than $500, it can be $1,000, it doesn't matter. The state still has the option to charge it as a 3rd offense. The prosecutor does not have to do that, but the prosecutor has that prerogative to do that. That's not impacted. So if you hear opposition testimony says, well, you're going to make a whole bunch of stuff that's felony misdemeanors, they still have the enhanced option.
Thank you. Thank you, Senator Blood. Senator Geist.
Yeah, the only thing I was going to ask is that if this is to account for inflation, which the gentleman said was around 3 to 7% that they calculated from 2017, but we're doubling we're doubling the fine or the amount, what we're raising it in. That's really not accounting for inflation. That's doubling the amount. Inflation hasn't doubled the cost of everything. So it's more than inflation, correct?
That's probably accurate. You are right. And I don't know how you add that all up year after year from when they were adjusted last, whatever the inflation was. But you're probably right. This is probably more. And that's something that I can't speak to.
Right,
Senator Wayne drafted the bill,
Yeah.
but I think that's what he's trying to do. And it could be what Mr. Seaman said. He's trying to make the dollar values comparable to what other states have. So, but you're probably right about that.
Okay, thank you.
Other questions from the committee? I don't see any. Thank you for being here. Next proponent testifier. Anyone else here to testify in favor of this bill? Then we will begin with opponent testimony. I kind of figured.
Committee members, my name is Don Klein, K-L-A-I-N-E. I'm here as a Douglas County attorney and as a representative of the Nebraska County Attorney Association in opposition of LB 19 for many reasons. I understand the inflation aspect, but I would agree that our inflation hasn't been 100%, which you would be if you're doubling the amounts. You know, and I can give you so many examples of why I think that I'm troubled by this. If something's a misdemeanor, number one, it probably doesn't get impacted as much even by law enforcement as far as the investigation. And so I see this kind of situation impacting people or lower middle income people more than anybody as victims. Because what we're talking about here, and I see it constantly, smash the window of a car, pull out a purse, pull out a computer that's there. College students, and I can give you several examples of that. And so, you know, if we make this $3,000 for a theft, that's not going to be a felony anymore. Probably not a whole lot's going to happen in misdemeanor land, or if the police are going to really work that very hard compared to a lot of other situations. The guy who's got a car that we say we get it appraised and that car is worth only $2,500. Well, okay, so that's just a misdemeanor then for him, car being stolen. But to that guy, that's how he gets back and forth to work every day. And that's how he takes his kids to school. And it might not be the most expensive car, but we're saying, okay, well, listen, that's not as big a deal. We'll make that a misdemeanor. So it affects people of lower income more so. And there are professionals in this business of stealing and forging checks. And I've been through that experience also, where it's amazing how people come in and write forged checks and it's just under the felony limit that they use. Same thing with using somebody's credit card. They know what the limit is between a felony and a misdemeanor, and they'll write a check or forge a check just under that amount, or they'll use the credit card only up to a certain amount that they know is going to be a felony. You know, I've got a guy right now that I give you anecdotal examples. 6 prior felonies. He's 27 years old and has a drug problem, obviously. He just got put on probation. Again, he's been to the penitentiary twice for the same thing. He just was on, when he's on probation, he stole a car, got the credit cards, used them. They had to use the helicopter to chase him down, caught him, brought him back in again. And we would offer that person we would offer even drug court to, even though the underlying crime's a theft, if the basis for his problems is drugs. Okay, I'm done. There's a lot of things, examples I can give you.
I'll ask you the first question, which is you can finish whatever you were saying.
Oh, it's just that, so that's the example of people who either because of, you know, whether it's catalytic converters or smashing out windows, people that maybe have drug problems. But when we make these penalties, I mean, extend it to a $3,000 before it's a felony, that has an impact on, I'll say, public safety in the criminal justice system, because people are going to get away with more, quite honestly, and they won't get the help they need again. Sometimes it takes that felony conviction for somebody to be in custody and they say, what am I doing with my life? I need to get help. And that happens. And that's how people get into our drug courts. They don't just walk in and say, oh, yeah, I'll go to drug court. It's usually because they have something that's happening. So that's part of this. And again, I think there's examples around the country where penalties have been lessened or lowered. The amount of money that it takes to commit a felony has been extended. And people are walking into stores, stealing a lot of items, and they know there's not really any consequences for that.
Okay.
Okay.
Let's see if there are other questions. We'll start with Senator Decay.
Thank you. If a person commits a crime, breaks into a store, convenience store, or whatever, and does this multiple times over, say, a 2-3 day period, whatever, and then are apprehended, is that considered one crime?
No, that would
For
be
the
multiple-
threshold?
That
or
would be
does that-
multiple crimes.
But does
And
it-
if they broke in, Senator, it'd actually be like burglary then. But if they just go in and steal something and run out, then it's a shoplifting in effect.
Well, if it's a high dollar item, does that threshold say from 1,500? Or is that considered as one crime and the threshold doubles to 3,000?
Well, if they grabbed a bunch of items and now it would have to be over
But each
$3,000 worth for it to be a felony.
In each incident.
Right.
Thank you, Senator Decay. Other questions? Senator Blood.
Just a quick question.
Sure.
So, actually, I have two questions. I'm sorry. So, you said look at other states. People are going in and stealing, and what other states?
Well, people have seen the videos in San Francisco. It's one of the reasons that Walgreens left that city. It's because there's no consequences for people that are stealing from stores. So Walgreens says, we're pulling out stakes in San Francisco because there's problems with the law. I mean, that's a pretty well-known fact. I mean, it's same thing Los Angeles. I mean, Union Pacific, I met with Union Pacific. They said, we're not going to ship through Los Angeles anymore because all of our container cars are getting broken into, stuff's getting taken, and they're not being prosecuted. So it's a problem, and some of it's because, they've expanded what the limits are with regard to what has to be stolen before it's a felony, and some of it's just because they're not enforcing the law.
What other states besides California?
Those are the only two that come to mind with regard to the theft crimes.
Is LA and San Francisco?
Yeah, the drug crimes that I talked about yesterday was like Portland and Seattle.
I'm sorry, I didn't mean to talk over you.
Oh, I'm sorry.
And then the other example, one of the examples you gave was somebody comes and they smash your car window, they steal your purse, and you talk about the victim, which of course the victims are important, and I don't want you to think I think otherwise. But do we not do restitution anymore in Nebraska? I mean,
We try to, but most of the time, either people don't pay it. If it's a misdemeanor in particular, that's what I'm saying, that it's not really something that's going to be, it's enforceable. Sometimes they can make a deal where if they plead to somebody, they'll get a fine as long as they make restitution.
Right.
That really doesn't fix that person, then doesn't have really much of a consequence there. But that's what I mean, it affects people, middle income, lower income people just as much as anything.
I'm sorry, what did you say?
Middle income, lower income people, because like I said, the value of a car, the value of items taken off the front porch, the value of items taken from a motor vehicle, whether it's a computer for a college kid and a backpack. We've seen multiple instances of that, and I think it should be a felony, not just a misdemeanor.
Fair enough, thank you.
Other questions for this testifier? I will ask one.
Sure.
Is there so the number is too high. Is there if we went up 5%, 10%, something like that, would that still be objectionable to you?
That might be negotiable. I mean, it's not very much, 5% or whatever it might be, but that's something we could talk about.
So it's not just, sorry to interrupt you.
No, you're not.
It's not just the concept, it's that you think this is too high.
Yes.
Got it. Thank you. Other questions? Thank you for being here.
Thank you.
Next opponent testifier.
Good afternoon again. Vice Chair DeBoer, members of the Judiciary Committee, my name is Mike Guinan, Mikeguinan. Again, with the Attorney General's office, I'm here before you on behalf of Attorney General Mike Hildress in the office in opposition to LB 19. We are opposed to this bill as it provides categorical and significant increases in the criminal offense thresholds, irrespective of the crime or the victim of the crime. Though the prices of consumer goods have increased recently given rising inflation, the proposed substantial threshold increases for all crimes does not logically follow and are not warranted. For example, retail theft of a consumer electronic device has nothing to do with the embezzlement by a government official, or someone writing bad checks, or a stolen credit card and then steal from a business, or someone who steals your identity and uses it to steal from you or somebody else. Moreover, these substantial and categorical threshold increases are not warranted given the across-the-board hike in thresholds just 7 years ago in LB 605. As such, the Attorney General's office respectfully asks that members of this committee not advance the bill to general file. Be happy to take any questions.
Are there any questions for this testifier? Senator Blood?
Yes.
Thank you, Vice Chair DeBoer. Thank you for testifying. I know you're the messenger, and I want to say you've done a fine job of testifying, but you've been here for pretty much every bill that pertains to us trying to put the puzzle together of how to keep people out of prison and work on the overcrowding. How come we don't see that same enthusiasm from the Attorney General's office when it comes to the hundreds of people that have been poisoned by alt implant in Nebraska? I think it's really interesting that, and again, Mike, you're doing a fine job. But I'm really curious how we keep seeing you guys show up for things, but you filed a case a year and a half ago, it'll be 2 years in March, and we really haven't seen anything except that we can't talk about it because there's litigation, which I think is actually really smart on your part because then we don't have to be complicit. So the concern that I have is this more of a priority than something like the alt implant to the Attorney General's office?
Well, I can't speak for the Attorney General himself. I can tell you that this bill, this categorical rise without respect to, in particular, any individual crime, this just straight across the board doubling. That is, I guess, the issue that we have with the bill. For instance, one of the section deals with bingo and pickle cards and so on, and those are being raised. And though inflation's going up, I don't know that those necessarily follow. I don't know why those thresholds. So that's our objection to this particular piece of legislation.
I appreciate that. I'm sorry that you're the one that got put on the spot. No
No,
matter who would have been here
that's
would have been put on the spot today. You guys have shown up for all these bills, and I'm always puzzled how we figure out our priorities. So
Sure.
thank you for being a good sport and allowing me to ask you that question.
You bet. Thank you.
Are there other questions for this testifier? I don't see any.
All right. Thank you.
Thank you. Next, opponent testifier.
Thank you, Vice Chair DeBoer and members of the committee. My name is Rich Otto, R-I-C-H-O-T-T-O, and I'm here on behalf of the Nebraska Grocery Industry Association and the Nebraska Retail Federation, testifying in opposition to LB 19, which would increase the threshold for felony classifications. Theft, including shoplifting, costs retailers billions of dollars each year. In an effort to discourage theft, but also reduce contact with police and incarceration, all 50 states and the District of Columbia have established thresholds distinguishing these offenses. In the last 20 years, 40 states, including Nebraska, have raised their felony thresholds. Nebraska's was raised recently in 2015. The handout from the page is a list of felony thresholds state by state, which includes Washington, D.C. You can see 36 states actually have a threshold lower than Nebraska, 9 are equal to ours, and 6 are higher. None have a threshold as high as 3,000. Theft, or shrink as it's often identified in the industry, affects retailers of all kinds, grocers, convenience stores, drugstores, which stock small, easy to steal items, tend to have fewer staff, often experience the highest incident, yet stores with high price items like electronics, power goods, tools, other things of that nature tend to hit the threshold and have a higher per incident amount that's stolen. I'd ask you to also consider not just our owners, but employee safety when looking at this. A lot of different policies on how employees handle this, and a lot of times, most often, our stores are discouraging from trying to apprehend at the point of theft due to escalation of violence. We understand why Senator Wayne brought the bill and would like the committee understand corrections is a big thing. But last year, we do want to also point out that Senator Aguilar had LB 603 last year, the Inform Bill. This bill was retail's attempt to let you know that we're going after the people that are running these syndicates. So it's not the individuals that are stealing that we're concerned about. Now, in the modern day of being able to steal and then sell online, this Inform Act, which was passed federally and will go into effect in June, I believe, basically says that these online sellers need to vet their third parties. Because right now you can still sell stolen goods online. It looks like it's legitimate. You think the consumer thinks I'm getting a great deal on this. It's half the price, but it's actually been stolen goods. So retail is trying to come up with solutions. We're not after the individuals. We're after the crime syndicates that are doing this. And we think that's a good first step in accomplishing that. I'm happy to answer any questions you may have.
Questions for the committee? Senator Geist.
How much do you write off each year for theft?
I can tell you my bigger box retailers, it is over 1% of sales and many times.
Okay, thank you.
Other questions? Senator Holcroft.
Thank you, Vice Chair. Good morning. So can you tell me what's with New Jersey here, $200 and they haven't updated it since 1978?
Well, I don't know New Jersey's situation. I do want to point out, I know the introducer brought up Texas and Wisconsin at 2,500. Our bigger concern is our neighboring states, Iowa at 1,000, Missouri at 750. We feel that, again, many of these thefts that are coming are organized retail crime. They prey on individuals that may have a drug problem in a tough situation, and those are the individuals going in to steal. We don't want those, if somebody is in the Omaha Council Bluffs area, they know what they're doing, and they'll gladly steal from Senator Blood's district well before they would steal in Council Bluffs because they can go up to the $1,500 threshold higher than Iowa. And so that is our bigger thing, is that these individuals are smart. If we go to 3,000, Nebraska is going to be preyed upon by people within a 500-mile district, 500-mile area or larger to come here and be able to steal 3 to 4 times the amount they could in neighboring states.
I thought maybe they had some different system for.
I can look into New Jersey specifically for you, Senator, and see why theirs is so low.
Thank you.
Other questions from the committee? Senator Blood.
Thank you, Vice Chair DeBoer. Thank you for coming in today. Can you tell me how many of these states that you brought forward have enhancement to felonies as part of their policy as well?
I know that typically when it gets raised, it is a thing that we bring up and they typically want that in. Now, if we're going to raise it, it's often a bargaining chip to throw what they would call enhancement or aggregation, where you can look at them together. And so those have been put in. And I can get the numbers on this. Rarely are they used. Rarely. And we can try to look at the numbers, but again, you have to be charged.
Why do you think that is? Because they're making negotiations in court, or?
I just don't think these rate on prosecution's radar or the app. I don't know the answer to that, why, but I don't believe it is commonly used.
Do you know how much employee theft is written off? I know you give kind of a percentage of how much is written off. How much of that is employee theft?
Typically, my members say when they're quoting that over 1%, that is not including employee theft.
Do you have any idea what that percentage?
I don't. I can look into that.
Do you think it's kind of odd that you brought a report from a story that says states can safely raise their felony theft threshold report?
That's where I got the numbers from.
I was just like,
I'm just comparing it to our neighbor state.
That's from Pew, because I remember reading that, right?
Right, I believe so.
Years ago. All right, thank you.
Other questions for this testifier? I don't see any. Thank you so much. Next opponent testifier. there anyone else who would like to testify in opposition to this bill? Is there anyone here who would like to testify in the neutral capacity? Anyone else in the neutral? All right, for the record, there are 2 letters, one in support and one in opposition for this bill. Since Senator Wayne is not here, that means he waives closing and will close our hearing on LB 19 and open our hearing on LB 553. Welcome to your Judiciary Committee, Senator John Cavanaugh.
Thank you, Vice Chair DeBoer. Thank you, members of the Judiciary Committee. Just gotta, here we are, 553. Got 2 bills here this afternoon, both similarly numbered. My name is John Cavanaugh, John Cavanaughh. I represent the 9th Legislative District in Midtown Omaha, and I'm here to introduce LB 553, which provides for an automatic bail review after 21 days for misdemeanors and city ordinance violations. Article 1, Section 9 of the Nebraska Constitution says, all persons shall be bailable by sufficient sureties. This lists exceptions. The question is, what is bailable? If the court sets a dollar amount and the individual cannot post that amount, are they bailable? This legislature has previously passed in 29-901, saying that the court shall consider all methods of bond and conditions of release to avoid pre-trial incarceration. If the judge determines that the defendant shall not be released on his or her personal recognizance, the judge shall consider the defendant's financial ability to pay a bond and shall impose the least onerous of the following conditions. LB 553 says that when a court sets conditions of bail for a defendant of low-level offenses and that person is unable to meet those conditions within 3 weeks, then the court has to hold a hearing to determine if those same conditions should still apply. And in light of the fact that the defendant could not post the bail, whether or not that person is still considered bailable. 553 would make review of the defendant's bail conditions for misdemeanors routine rather than something extraordinary. It does not in any way eliminate a judge's ability to impose the same conditions, but makes it the process for getting in front of a judge automatic. LB 553 would make review of a defendant's bail condition. Oh, that's the same section. Sorry. Considering what would happen if you didn't show up to work for 2 consecutive weeks or 3 consecutive weeks, you'd likely lose your job, and as a result of that, being in the system or on pretrial release is a primary basis for that your job is your primary basis for your ability to pay a cash bond. In my experience, I've seen people lose their jobs, their houses, miss doctor's appointments, and the progress they've made on getting their life together when they're detained even for a few days. So basically, what I'm saying here is the Constitution says that somebody has to be bailable unless they're held on a homicide or a serious sexual assault. This bill would say if you're held on a misdemeanor and you're in jail for more than 21 days, that the dollar amount that was set clearly didn't contemplate your ability to pay correctly as is required under the statute. And if your ability to pay is not properly considered, are you actually bailable as the Constitution would require? So all it does is says that a judge needs to reestablish, re-review conditions of bail every 21 days to ensure that they are properly considering someone's ability to pay and that someone's not just sitting in jail because they cannot pay and they were inappropriately determined to have a higher ability to pay. So I can take some questions if you have any.
Are there any questions from the committee? Yes, Senator Barr.
Thank you, Senator Geist. So I just have a quick question. So I always worry about bills like this, not because I don't think it's a good idea, but because we put more mandates on local government. Would you agree with what the fiscal note says from NACO? Because I actually think that that's very positive, that it assists in potentially reducing the days of stay for defendants, therefore reducing the costs incurred for lodging of defendants.
Well, yeah, I'm a strong subscriber to that philosophy that if we do not detain people we don't need to detain, we don't have to pay to detain them. So we can save dollars for every day that someone's not sitting in jail.
So the sky is falling on the other fiscal notes. Maybe need to be more balanced because it sounds like their costs may be balanced by the fact that we're not incarcerating people that don't need to be incarcerated.
Well, yeah, certainly. And I would point out that the amount, these are people who are already incarcerated. That's the biggest cost. The only cost is really, honestly, I've personally done thousands of misdemeanor bond hearings. It takes about 5 minutes. And
There's still the transportation. They have to be transported, right?
not necessarily. They're doing a lot of those bond hearings via video conference now. And they have, at least in Douglas County, there's a courtroom in the jail, and they do bond hearings every day through that courtroom. And so essentially what this would require is that on the 21st day or the next business day after that, that person would have to be put on the list for that bond hearing. And then that essentially the bond that was either previously set would be reviewed and reaffirmed, or potentially in light of this new information, the judge would have the opportunity to say, well, really, this is an offense that doesn't require you post $1,000. We just said that because we thought you had the ability to pay that. And now it's clear you've sat for 21 days. That seems like a demonstration that you don't have $1,000.
So you don't see this as a potential burden for the more rural areas that they probably would have to drive somebody? Depending, because I know a lot of times the jails are the same building as the court.
Right.
Like Adams County is an example.
Realistically, it could be, for a rural area, it might be a little bit more burdensome, but they're not going to have very many people that are in on a misdemeanor anyway. This is more a consideration. I can tell you that the numbers in Douglas County is 55 individuals are currently in Douglas County on a misdemeanor right now. So, and that's our biggest county by far. So rural
What's the
counties.
cost per day for the, I know it is for state prison, for jail in Douglas?
You know, I recall it being something like $80 a day, but I don't know if it's gone up or down since then. Well, I assume it's gone up, but I don't know if that's what they're.
So 80 times 21?
Yeah.
Okay, thank you.
Other questions? Senator Decay?
Yes, so if they're not making bail in 21 days, the judge has a chance to reestablish what the bail will be. And if it's a misdemeanor and it goes forward, does that also count as time served for them?
Yeah, so this only applies to misdemeanors. I'm not saying we have to review felony bonds. But yeah, anytime that somebody is sitting on an offense and they say, hypothetically, are convicted of that at a later date, they would get credit for the time that they've served towards that. And that's ultimately what happens in most of these cases. If somebody sits for that long and they get to their trial date, which is maybe 60 days down the road, and they get convicted, most misdemeanors are going to get time served at that point. And really the problem we have is if somebody posts a bond on day one, they come in, they go cycle through, they get either an ROR, release on their own recognizance, or they get a small enough bond that they can post. That person gets out, they come to their trial date in 60 days, and they get a fine or they get probation. But if you sit there for 60 days, aside from losing your housing, losing your job, missing all those things, they're going to say, well, you've already done 60 days, we're just going to give you time served. So the difference in penalty there is, one, you spent all that time there and you lost all those things. But two, you have on your record a conviction that shows you did 60 days in jail. Whereas if you had $500 in the front end, you probably get probation. And so your record reflects differently as well for purposes of a set aside, for purposes of some, how you report it to employers and things like that in the future, and for purposes of how your record looks if you happen to come back. So it has a lot of those other ancillary effects just based on the fact that you couldn't come up with $500 in the front end.
Thank you.
Other questions? Senator Geist?
So on the front end, when someone comes before a judge, does the judge not consider the person's ability to pay?
No, they do, and they're required by statute to consider ability to pay. What I'm saying is, say they look at you and they hear all of the evidence about you that they've got, and they say, okay, $500 cash, so $5,000 bond is the right amount. What I'm saying is, if you don't pay $500 over 21 days, that is evidence of that they were incorrect in their assessment about your ability to pay. And so it's new evidence that should be considered in reestablishing a bond.
Okay. Gosh, okay. Seems like the judge could ask a lot of questions though, and find out that on the front end.
They can, but in a adversarial criminal justice system, there's some hesitation to believe somebody if you say, how much can you pay? And they say $400. I say, I don't believe you. I think you can pay $500. Very common to have that conversation. And I'm not saying that that's the wrong approach to take. I'm just saying that this is a pretty solid evidence that you can't pay it if you're sitting in jail on it.
Thank you. Okay, other questions? I don't see any. Let's have our first proponent testifier.
I usually come even though I like to be past it, to share my past experience because I've been on the other side of these things. Jason Whitmer, WITMER. Way back when I was getting in a lot of trouble, I went to jail for different things. But there was times when I didn't do much, but I went to jail for misdemeanors, and I've been in a position where I didn't have no money to pay like $1,000 bond. And you just sit there for day after day. But it's just like they said, I've been in jail once where I had a job, and they're not interested. First of all, if you go to jail, you're guilty for work. They're not trying to hear, some jobs, if you don't have a good established history, they're not trying to hear why you're in there. They just know that you're not showing up at work. So by the time I come out, I have no job, and I'm back on the course of what was getting me in trouble in the first place. Instead of the job, which was starting to put finances in my pocket to pay bills, to shift to something else, I just went back to what I believed I knew and thought was best. And I just think that's a perspective you should look at when we say, like the no bill places, the no bonds or the low bonds, and like that's just letting people, but one, we say innocent until proven guilty. And two, we're talking about misdemeanors. If somebody's gonna rampage on a misdemeanor, I don't know what you do about that, but what you are doing when you're not adjusting something like this is kind of putting them on course to get back in, not do well, lose the job, that was mentioned. So I actually been in that position, and things escalated for me, and of course things escalated for me a lot further than other people. However, I can't imagine what it would be like to be a single mother or a father or somebody who has these troubles, and then you go into the jail and you can't pay your bond, and you can't get somebody to get to your house or whatnot. So there's so many dynamics to this. I just feel like this is kind of a simple one in the basis of the impact it has not to do it is much harsher than the impact that you might feel that it has to do something like this, because this doesn't lesser crime, lesser charges. I mean, it's just something to just so people can do what they need to do and not fall into a rabbit hole, because that's what happens. You fall in a rabbit hole when you get these little things on you, and it adds up to what it shouldn't even be adding up to. Guilt is meant for a reason. Guilt. Misdemeanors shouldn't be punishment already. That's it.
All right. Are there questions for this testifier? I don't see any. Thank you. Next proponent.
Good afternoon, members of the committee and Vice Chair DeBoer, members of the committee. My name is Spike Eichholt, S-P-I-K-E-E-I-C-K-H-O-L-T. I'm appearing on behalf of the ACLU of Nebraska and on behalf of the Nebraska Criminal Defense Attorneys Association in support of LB 553. The page is handing around a report that the ACLU published a few weeks ago, maybe actually a couple of months ago. In 2018 and 2020, the legislature made some various reforms to the bond statutes and also the statutes that relate to court's ability to impose fines. And it basically required on both the front end of the court system and the case and in the back end of the case that the judge is required to consider the financial ability of a defendant to pay. If it's the financial ability of the defendant to pay the bond, to be released, to come back to court and contest the case, and also if the court imposes a fine, then the courts are directed to make sure that the defendant has the ability to pay that fine. These bills were generally supported overwhelmingly by the legislature, and in part they were supported by a number of people, or at least not opposed by the various interests, for something that Senator Blood mentioned before, and that is a lot of these low-level crimes, particularly in Lincoln and Omaha, if you lock somebody up and set a bond that's too high, they simply sit in your jail for an arbitrary length of period of time. And similarly, if a person is imposed, the court imposes a fine on them and they cannot pay, then what will happen is they will eventually be arrested and required to what they call sit out that fine in the jail system. The other day, you heard a bill that Senator Conrad has that would provide for some sort of tools for the courts to allow people to be released short of posting a cash bond, but to have some supervision and rehabilitative care. That's why that's important and why it fits in this bill as well. But what this bill does provide is for people who have bonds that are set, a money cash bond that's set and they cannot post after 21 consecutive days, the issue goes back in front of the judge. You may hear from an opponent testimony today, and it is true that under current law, a defendant or the defendant's lawyer can always file a motion really at any time to review that bond. And that does happen. And as Senator John Cavanaugh said before, I've done hundreds or thousands of those myself over the years. But what this does, it has an automatic tool or an automatic way that courts are going to look at everyone's bond in a misdemeanor or city ordinance case and make sure that it's properly set and review that situation again. So we would encourage the committee to consider this bill, and I'll answer any questions if anyone has any.
Are there questions for this testifier? I don't see any. Next proponent testifier.
Good afternoon again. Vice Chair DeBoer and members of the Judiciary Committee. My name is Jasmine Harris, JASMINEHARRIS. I'm the Director of Public Policy and Advocacy with RISE. I like to bring in data and perspectives from people who have been impacted so that we balance out all of the lawyer and legal speak that comes in. So according to the Prison Policy Initiative, Nebraska's incarceration rate is 577 per 100,000 people, which includes prisons, jails, immigration detention, and youth facilities. This rate is higher than countries like the UK, Canada, and Italy. So that's a state who has higher incarceration rates than countries. The National Institute of Corrections reported that in 2020, the jail population in Nebraska was 4,240 individuals in 63 county jails. And although that number sounds low, we don't take into account the transient nature of the population that comes in and out of these jails. So annually, the unique jail admission is about 30,000, with over 70,000 people being released each year. We continue to ask for alternatives to help alleviate overcrowding, as we see our county jails are dealing with this as well. And the solution must be a proactive approach. At RISE, we believe that alleviation can happen on the front end by addressing the county jails and the pretrial system. And as part of our policy and advocacy work, we are interested in identifying and addressing those gaps and opportunities related to the pretrial justice system. In 2020, we asked community members through an assessment of our pretrial system here in Nebraska. 78% of respondents disagreed with the statement that no one is detained due to the inability to pay a financial condition for release. According to the Board of Governors of the Federal Reserve System's Economic Well-Being of U.S. Households in 2020 report, 35% of adults faced with an unexpected $400 expense would have had difficulty completely covering those expenses. So we currently have people sitting in our jails in Nebraska with a $5,000 bond, meaning they only need $500 for release and cannot afford it. This continues to perpetuate cycles of poverty and incarceration. It results in people who do not have disposable income spending days to months in jail that further impact their livelihood. And it takes only 3 days before someone who is jailed and cannot afford cash bail to potentially lose their employment, housing, and custody to their children. And we must remember these people have only been charged. They are innocent until proven guilty. So we have them sitting incarcerated and have not had their due process yet. We're asking that LB 553 be voted out of committee to general file, as this is a step in the right direction. Best practice is that these reviews happen within a maximum of 48 hours, and we currently have no automatic review here in our state. So at least having 21-day review is getting us to that right direction.
Thank you. Are there any questions for this testifier? I do not see any.
Thank you.
Next proponent testifier. Any proponents? Anyone here to testify in opposition to this bill?
Good afternoon, Vice Chair DeBoer, members of the Judiciary. My name is Patrick Condon, Patrick Condon. I am the Lancaster County Attorney here testifying for Lancaster County and also for the Nebraska County Attorneys Association. We are opposed to LB 553, in particular because this is already in the statute. If you read the bill, the initial first paragraph talks about the ability for individuals who have not posted bail to have their bail reviewed within 24 hours after having bail set and not being able to post it. So this can already be done by any individual. It just sets up now an automatic review of those bonds within 21 days. What the bill doesn't say is who's responsible for that. Is that the jail that's supposed to keep track of the 21 days? Is it the defense attorney? Is it the court? Is it the prosecutor? Who is supposed to keep track of those 21 days? And if it is missed, is that a lawsuit that's potentially there on the jail for holding somebody past those 21 days without having that reviewed? So that's also a concern. The last testifier, the last proponent for this, talked about that individuals are innocent until proven guilty. That is correct. But on any case where a bond is set, there is a probable cause affidavit that's also filed with the court, and the court makes a probable cause finding in regards to any case in which an individual is in custody on a bond. If they do not have a probable cause affidavit, then it is set as a PR bond or an OR bond. So there is a review of individuals that are in custody prior to, they just don't sit there without having some type of judicial review. So with that, as I said, those are the things that are concerning to us. One, the fact that this is already something that is available to be done. Two, it doesn't say who is responsible for that, and there is a review of the individuals in custody if they have a bond set. And with that, I would entertain any questions.
Are there any questions for this testifier? Senator McKinney?
Yes, thank you, Senator DeBoer. So your argument is that it's already in statute, so what's wrong with it being automatic?
Again, the question is why? I mean, who's gonna be responsible for making sure those individuals get back? And then if they have a bond review at day 20, and then automatically at day 21 they get another bond review, that seems to me to be wasting resources of the judiciary.
But I'm gonna operate in the assumption that if day 20 and day 21 are that close, somebody is smart enough to realize day 20 or day 21 is gonna make, you wouldn't do the both in 2 days. Like you wouldn't say, oh, day 20 come in, day 21 come in. I'm not gonna operate with the assumption that people are not smart enough to figure that out. Also, what if Senator Cavanaugh amended the bill to say who would track? And I'm sure you'll probably still disagree, but in the hypothetical that you wouldn't, who do you think should track this?
Well, and I guess what I would say, Senator, is it depends on if that individual has an attorney or not.
No, I'm saying, so regardless of them having an attorney or not, who should track it? The county facilities, the courts, who? And
well, I think it would put us in a.
Would be best suited to track?
Well, I think the defendant. I mean, the defendant knows how long they're in jail, and if I don't want to get involved and interfere with the defense attorney and their defense of this case, however they may see that they want to go forward with it.
But if it's automatic, the defense attorney would have a different strategy because it would be automatic. So you are not going to say who should or shouldn't. I just fundamentally have it, and you don't even have to respond, but there's many individuals that sit inside of county jails only because they cannot pay to get out. And because of that, they lose a job, housing, probably their kids. It's all type of, it's a ripple effect. And all this is actually just a review, of automatic review. I don't see it, and I think this is the problem where county attorneys and why people get so frustrated with y'all. it's always the sky is falling, no, and y'all act like you're not humans. And that's the problem people have. And you don't have to respond, but I would say to you and other county attorneys, and you can say it to the people you work with, that you guys need to have some type of humanity on both sides. It can't just be victim, 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 but you don't have no humanity for the other person on the other side. It's not to disregard what they did. Yes, we can hold them accountable, but you also got to be humans. And during my time here, you and others who come in here, y'all lack a lot of empathy and humanity, and that's the problem. And that's why people get frustrated with y'all. Thank you.
Can I respond or?
Thank you.
Are there other questions? Thank you for being here.
Thank you.
Next testifier in opposition. Is there anyone here to oppose this bill? Anyone in the neutral capacity? As Senator John Cavanaugh is coming up, I'll say that there was one letter of support for this bill. So Senator Cavanaugh, to close.
Thank you, Vice Chair DeBoer, and thank you, members of the Judiciary Committee. And Senator McKinney, to your question or point, there certainly I would be willing to tighten up the language in here. The language says that a person is entitled to this hearing. And the Constitution says that a person, unless they're held on a homicide or a sexual assault, must be bailable. And the statute previously adopted says that a court has to consider ability to pay when considering what makes someone bailable. My point in this bill, though I would like it to pass, is to point out exactly what you're getting at, is that there are folks who have a cash bail that's set and they can't pay it. That is effectively making them not bailable in violation of the Constitution, in violation of the statute. And this is giving the courts and the prosecutors really an opportunity to revisit that and say, in either correct a mistake or to explain why it is not a mistake, why that person is bailable, or why that is within their ability to pay. As I said, I've done hundreds of thousands of these hearings. And when you are on that side of the bar, the defense bar, you operate in a very, I would say, gritty part of reality. And one of the aspects of that reality are that you do have an opportunity to ask for a bond review basically every day. However, when you do that, you put yourself, your client really, in a position to upset the court for causing that work, for putting them to work. So what I'm doing here is saying that the system is essentially unjust when someone is in jail because they cannot post a cash bond. And I'm saying that the person the court should be mad at is us, because the court should automatically has to review that bond. And so I don't want people coming into court and asserting that they don't have the ability to pay and having the court be frustrated with them. In the number of times I've done this, I brought somebody in about this time scale, I would say, and the first question the judge will say is, what's the change in condition? And that's where I came up with the idea for this, because I would argue, and I continue to argue, the change in condition is the fact that they've been in here for 21 days. That is evidence that they can't pay this. And certainly they've lost their job, they've lost their house, they maybe lost their kids, they missed doctor's appointments. So all of those things have changed. But when you talk about the change in condition that the court wants to consider, those things don't meet that standard. And what I'm saying is they should. And that's what the point of the statute is to say, is that sitting in jail without the ability to pay is evidence that the bond is too high and that you are unbailable and that we are violating the Constitution. So whose obligation is it under this? really, it's probably the courts, and it should be the courts. And so I'm happy to put in language that explicitly states that. And well, I could keep talking, but I don't know if anybody had any questions. But I've got the jail data. I can tell you there are 861 individuals currently sitting in Douglas County Corrections pre-trial. There are 55 of them are sitting on misdemeanors. But that means there's 861 people there who are sitting on a range from an offense that carries, 30 days, 60 days in jail, up to an offense that carries life or death, really, in the state. But the vast majority of them are people who are going to get a sentence of somewhere around the lines of 60 days. And a lot of those, the reason for that is that they're getting time served because they've sat there for that entire time. And then those folks have to start their life over again. So I think it's a simple bill. I think it's a simple premise, and I think it's something we probably should have done a long time ago. So.
Any questions? Senator McKinney?
Thank you, Senator DeBoer. Thank you, Senator Cavanaugh. Can you speak to the ability to be able to fight a case outside of a jail versus inside, and how those outcomes are a lot different?
Well, I can't cite specific stats and data, and certainly, yes, that's a good point. So, when somebody's incarcerated, they're just much more likely to take a plea deal, right? They're gonna, the longer somebody's in, the more likely they're gonna plead guilty to a charge, whether they have a good defense or not, and especially on a misdemeanor, because really the court date and the sentence are coextensive when you're in. And so in that regard, it essentially acts as a coercion into pleading, taking a deal just to get it resolved and move on with your life.
So it's beneficial for county attorneys to oppose something like this because of the probability to get more pleas.
Yeah, I mean, really, when people are incarcerated, it probably does make their job easier, sure. But yeah, in terms of fighting the charge, 100% right on that too, right? If you're out of jail, you can work with your attorney more easily. They don't have to set a time to come visit you at the jail. They don't have, you can get your papers together. I mean, the number of times somebody said, well, I had, if it's something that requires a cell phone or technical, like some billing or something like that, getting that kind of stuff together is impossible. When you're in jail, you have to have somebody on the outside that helps you out with those sorts of things. Tracking down phone numbers and things like that to help, just to have your attorney have somebody to call to talk to conduct that investigation. All of those things are so much harder from the inside in ways that, those of us who've never been in that situation can't even contemplate. So yeah, it is a lot easier to defend yourself, and it's you're much more likely to do it when you're out.
Thank you.
Other questions? I'll ask you one. You say that it's much more difficult, they're more likely to take a plea deal, that sort of thing, but have you had situations where someone was sitting in there unable to pay bond and then was acquitted?
Yeah.
So they just sat there and then they were acquitted?
Yeah, I've won jury trials with somebody in custody before, yeah.
Okay.
I'm sure other people have as well.
That seems horrible for that person.
Well,
yeah. All right, thank you. Are there any other questions? All right, I think then we'll close that, means the hearing on 553, and we will open on 555. Welcome back, Senator John Cavanaugh.
thank you, Vice Chair DeBoer. And I'm going to try and be brief on this one because I got some other folks here who can probably do the explanation portion better than I can. But my name is John Cavanaugh, JOHN-CAVANAUGH, and I represent the 9th Legislative District in Midtown Omaha. I'm here to introduce LB 555, which would allow for an additional funding source for the Commission on Public Advocacy and the state legislative intent to transfer the indigent defense fee to the Legal Aid Services Fund if the commission receives $2 million in general fund appropriation. And just so you know, I have a bill in appropriations to appropriate those funds. So I'm not asking for that here. This bill is the result of an interim study I introduced this last year, LR 396, attempting to find a long-term funding solution for the commission. The Appropriations Committee held a hearing in October but reached no consensus. The Commission on Public Advocacy serves a vital role in our criminal justice system. Created in 1995 by the Legislature, the Commission provides legal services and resources to counties in fulfilling their constitutional obligation to provide effective assistance of counsel to indigent persons. In larger counties, full-time public defenders handle the vast majority of indigent clients. The Commission steps in where there is a conflict of interest or the public defender's office otherwise cannot represent a client. In smaller counties, defense will typically rely on court-appointed counsel. It is here where the commission is essential to providing an adequate defense. Because the commission's resources are limited, they typically only are able to take a major felony and capital cases. These types of cases cost a lot of money. The commission can take on that cost at no expense to the county out of its budget. But the commission is funded by court fees. Revenue from court fees has been declining over the past several years. Thanks to the success of alternative resolution programs and decreased case filings, court fees are not a reliable funding source year to year. Additionally, raising fees diminishes access to the courts and overly burdens those least able to afford the increase. States like Kansas have gone entirely away from funding anything through court fees and has moved these type of programs to general funds. It's time for Nebraska to do the same. The Commission on Public Advocacy is an essential function of the state and should be funded through general funds. And just, I guess by way of interest, I've got an article that was in the Journal Star here. I think, can I give this to the clerk or the pages? Can you make copies and hand those out? But basically it shows you how many lawyers we have in each county in greater Nebraska and then what the projected future is going to be. Basically, we don't have a lot of lawyers in rural Nebraska, and in the future, we're not looking like we're going to have a lot more. And so that's why the commission is important, and that's why I'm looking to figure out how to make sure it continues into the future. So now I'll take questions.
Other questions? Senator McKinney.
Thank you. Senator Cavanaugh, can you elaborate more on why charging court fees is bad?
Sure. So I'm trying to think of a good example. So like a misdemeanor court fee is, I think it's $49 right now, and it goes to a whole lot of things. And so the Commission on Public Advocacy is about $3 of that. And so, you know, that dollar amount, if you were to increase it, which realistically we'd have to increase that, and then all the other court things that are supported by court fees need to go up as well. You start getting to a point where it becomes very onerous. And so in a misdemeanor case in county court, $49 court fee right now, say you get a fine and you get time to pay that, you fail to pay, your driver's license gets suspended because you didn't pay those court fees. You can get a warrant for failure to pay those court fees. Or, as I think Mr. Eichel referenced in the last hearing, people sit out fines. And so then people end up sitting in jail. So these court fees, in that instance, can then become a way in which somebody then continually comes back to court to get more time to pay those. They have to take time off work. They lose their license. They can't drive. They get a traffic ticket for driving on a suspended license. It becomes a cyclical problem that keeps people in the criminal justice system. But on the other hand, there's things like small claims court. So if you need to file small claims for whatever reason under, I think it's $5,000, something like that. The small claims court fee is $29. Of that, the indigent fund is, again, $3. So it's about 10% of what it costs you to gain access to small claims, which is something that when you're going to small claims, obviously it's a smaller dollar amount. And so you're increasing the burden, the barrier for someone to avail themselves of that court system by raising these court fees. And all of the things that we fund through court fees, judges' retirement, which we raised 2 years ago, if you remember. And in that conversation, we raised it on civil filings, but not criminal filings. And judges' retirements, I think on criminal filings are something like $7 to $9 right now. We have technology fees that pay for the technology of the courts. We have the fee that I'm talking about moving this money into funds things like legal aid, and you'll hear from some folks there. So the court fees fund essential things that that I like, that you like, that we all like, but on the backs of poor folks who are least able to pay it. And if we continue to be dependent upon these things, you're going to, one, increase that burden, cause more people to have the problems I'm talking about, and you're going to further shut off access to the courts for everybody and make it just more difficult for anybody to avail themselves of the justice system. And so we need to find other ways that are more sustainable.
Thank you.
Other questions? Senator Decay.
Senator Cavanaugh, I'm pleased to see you bring this bill before us today. I was just wondering, there's going to be a similar bill probably brought forward later on. By raising the court fees, would that, or using the court fee system, would that help maybe put in perspective that the money is going for what it's supposed to be used for rather than going into general funds and just getting a set amount at the end of the day to fund these trials and stuff that are coming forward?
All right, so I guess is your question about transparency? Is that it?
No, it's just, I mean, it gives credence to why the court fees, in my case, why the court fees are used rather than going into general funds after, just to get a lump sum to start to pay off the public defenders and stuff. So that's where I'm coming from. But I want to reiterate, I do applaud you bringing this forward. I think this is something that we will be able to work out at the end of the day. Like I said before, I don't have a real problem on how the money gets there. It's just that we all get to the target date at the end of the road. So however we can work together on this, I'd be open to those conversations.
Well, I appreciate that. And yeah, I can tell you the broad strokes of how we got to be where we are, where I'm here talking about this. I've historically opposed increases in any court fees, but I believe strongly in the mission of the Commission on Public Advocacy. And so I opposed their increase that they came and asked for a couple years ago. And so as a result of that, I said, well, let's find a way to fund this. And my opposition to court fees is one thing, and I think you'll hear this from somebody else who will testify, but the court fee, the dollar amount's been $3 for a while, but the amount that has been generated as a result of that has continued to go down. And what that tells you is that a court fee is an incredibly unreliable way to fund a program. Because what happens is if we increase the court fee and we say we need to get to $2 million, we need to do that with the number of filings we had last year, got to do this amount. What you'll have happen is in 5-10 years, you're going to need to increase that court fee again, right? Because the filings are on a downward trajectory. And so that's why states like Kansas, what Kansas did was they just took all of their court fees and put them into the general fund, and then they funded everything from court fees out of general fund. And so the reason they did that was their courts were going to have to shut down because the filing fees were so low and they weren't getting enough money coming in. And that's kind of what we're looking at with Commission on Public Advocacy is if we don't give them money, which we did the last 2 years to continue operating, they won't be able to provide the services to some counties in your district. Some counties in Senator Ibach's district they do cover some of Lancaster. They have had cases. I mean, they've had cases that in Douglas, Lancaster before as well. But really, the value they bring to the state is, and you can see from the article I handed out, is doing these high technical cases, a lot of work in rural Nebraska, where there are basically either no lawyers or no lawyers who have ever tried a homicide before. And so that's why it's a general fund obligation. This is a value that comes to the entire state. And court fees come from predominantly poorer people in Douglas County. And that's why I want to find a way to solve this problem.
Just a quick question on, general funds part of it. So would this be a rollover effect, if we're starting to use those funds on a specific trial so that we would want to come back here, say in a year, 2 years, however, when the funds get as low as they are right now, would we need to readdress this going forward ask general funds for more money going forward?
I mean, I think in an ideal world, it would be the commission, we would treat the commission like any other general ongoing obligation. So they would come through budget process and say, we need $2 million for this year, or this biennium, to operate and do to do the number of cases that we expect. So it's not on a case by case, where they're not appropriate, wouldn't be on a case by case basis. But if they don't have the lawyers, they can't take the cases. So if we don't give them enough money, they can't hire enough lawyers. They're just going to have to turn down cases. And then if they turn down a case, essentially the burden falls to the county. The county is the one that has to pay the legal fees for an indigent defense appointment. And so this is the reason that the commission is property tax relief to rural counties, is that some counties, and I'm sure somebody behind me can say that, it can reiterate this, but they have examples of cases where there's been co-defendants and they've represented one, and the other one cost the county something like $800,000 to appoint representation for the co-defendant. So you could say they saved that county $800,000, give or take. And so the other thing about this, the interesting dynamic, is you can't plan for this. You couldn't have, Knox County can't say, we're going to have a homicide in the next 3 years and we need to set aside $800,000 over that time. They happen, can't predict them, and then the county has to pay for that representation. I mean, not always, but most of the time in a homicide, they're not going to be able to afford the representation. And so it helps with that, for that budgetary purpose. It helps ensure that we're having quality representation in these cases, which then means you don't get to this appeal into the ineffective assistance of counsel situation where then the case gets kicked back down and has to be retried. And it pursues the interest of justice, that people actually are getting quality representation. But so it saves money, promotes justice, and the issue here is where the money comes from. So I'm just trying to find that solution. Actually, and really what this bill does is says if we do fund them, then we take the current pot of money and put it into other valuable services. And some folks behind me can talk about that.
In an ideal world, we wouldn't have to have these cases to try, but
Yeah.
I do appreciate you bringing this forward. I look forward to conversations, and at the end of the day, that it is funded however we need to fund it to get it to the levels we need to keep county courts out of harm's way of being bankrupt or having to go to local lenders to borrow money to run their basic county business. So appreciate that. Thank you.
Thanks.
Other questions? Seeing none. First proponent testifier. Welcome.
Thank you. Again, my name is Jeff Pickens, Jeffpickens. I don't know why I'm looking at my notes to spell my name. I'm Chief Counsel for the Nebraska Commission on Public Advocacy. I've been with the commission since the beginning, all the way back to 1996. The commission is appointed to represent indigent defendants charged with capital murder and other serious violent felonies throughout the state. We provide our services to the counties at no cost to the counties. I don't think we can talk about LB 555 without talking about LB 554, which Senator Cavanaugh has addressed. 554 appropriates $2.1 million from the general fund to the commission for fiscal year 2023, 2024, and fiscal year 2024, 2025. LB 55 is contingent upon the passage of LB 554, which, of course, both those bills were introduced by Senator Cavanaugh. I support LB 555 to the extent that if the commission receives more than $2 million from the general fund, the indigent defense fee would be used and transferred to the legal aid and services fund. I want to talk a little bit about the reason why the commission was created. Initially, we were created because of a problem in Richardson County. They had two high-profile murder cases, one in the 80s, one in the 90s. And in both cases, there were death sentences. And in both cases, Richardson County had to go to lawyers in Omaha and Lincoln. And Richardson County was on the brink of bankruptcy and had to take out a bank loan to pay for the lawyers that they had to hire in those cases. We were created in 1995 and started taking cases in 1996. Initially, we got general funds, and then in 2003, we were switched to cash funds. We initially received an indigent defense fee of $2.75. In 2005, that went to $3, and that's where it's been ever since. The number of cases that are filed in courts has gone down every year since fiscal year 2008, 2009. The commission's revenue has dramatically declined because of the reduction in case filings. In fiscal year 2021, 2022, our revenue was around $540,000 less than the revenue we received in fiscal year 2008, 2009. I provided you a handout with respect to LR 396 that Senator Cavanaugh addressed, the interim study regarding the commission's funding issues. That provides an awful lot of information about the commission. There are charts in there that show the revenue issues. In the study on page 6 and 7, you can see how our revenue has declined every year since fiscal year 2008, 2009. And then there's also an attachment to that that shows projected revenue and expenses going forward. I am out of time. Hopefully somebody will ask me a question.
Are there any questions for this testifier? Do you want to finish up in like 2 sentences?
In 2 sentences. That's hard to do. What I would like to tell you is that since 1996, we have handled more than 1,500 cases throughout the state. Those are cases involving capital murder, other homicide offenses, kidnapping, sexual assault, robbery, child abuse, other serious violent felonies. We have provided our services in 72 Nebraska counties. We have handled at least 185 defendants who were charged with murder in at least 53 counties. We've handled 13 cases in which our clients were sentenced to death. We represented Kerry D. Moore at the time of his execution. I have much more information I'd like to provide you. Luckily, a lot of that is in the handout.
Perfect. Thank you so much.
Thank you.
Other questions? Senator Takei.
Just a quick question. Where the cash funds are now, and however this money comes forward, if it does, and I'm confident we can get there, can we get to the level we need at an $8 per filing or not?
Yeah, and I should mention that you have graciously introduced a bill for us, 767, which increases the indigent defense fee from $3 to $8, which is what we need now in order to continue to operate. I should say that our expenses are down right now, but only because we lost a lawyer in May, and we cannot afford to hire another lawyer to replace that lawyer. So we're taking more cases than we can handle at this point. We're not going to be able to continue to do that. At some point, I will not say no to an appointment in a murder case. At some point, we might get there, and then that's going to fall on the county. And as you know, in the case of Saline County with Aubrey Trail and Bailey Boswell, Aubrey Trail's lawyers have been paid well over $300,000. We represent Bailey Boswell for free to the county. If we weren't here to take that case, 2 other lawyers would be appointed to represent her, and their bill would be similar to what Aubrey Trail's lawyers are billed.
You're at 6 lawyers now?
We're at 5 now.
You're 5 now.
Since 1996 up until last May, we always had 6 lawyers. We lost a lawyer in May. We're at 5. We can't afford to hire another lawyer to replace her. For many years now, we could have used a 7th lawyer. And the important thing to know about that is if we had a 6th lawyer and then a 7th lawyer, we would be able to take on more cases. And the more cases we could take on, the more property tax relief we can provide, and that is the reason why we were created, is to provide property tax relief. The act initially back in 1995 is called the Revenue Assistance Act, and it's still called that. It's codified at 29-3919. And the legislature's findings for creating the commission are found in 29-3920, which includes providing assistance to the counties in the event that they have high-profile murder cases that can significantly impact their financial resources. Thank you, I appreciate it. Thank you.
Thank you. Other questions? Thank you very much for being here.
Thank you.
Next testifier, next proponent.
Good afternoon, Vice Chair DeBoer and members of the Judiciary Committee. My name is Lori Hairdale, and that's spelled Laurieheerdale. I'm the Executive Director of Legal Aid of Nebraska, and I want to thank you for the opportunity to be here to testify in support of LB 555 today. Just briefly, I wanted to mention Legal Aid of Nebraska is a recipient of the Legal Aid and Services Fund, which is really what this bill would increase, right, if it passes. And so I wanted to also mention that we receive the largest share of the Legal Aid and Services Fund. So this bill is critical for us, and we obviously very heavily support it. So Legal Aid of Nebraska is the only statewide provider of direct and free legal services to low-income individuals in Nebraska. We have 7 offices across the state. We employ about 100 individuals. About half of those are attorneys. We represent folks in all 93 counties of the state, and we do that through cases involving housing law, family law, consumer law, juvenile law, and public benefits, just to name a few. We represent folks who are, or households who are at 125% or less of the federal poverty level. So for a 1-person household, that's about $17,000 a year. For a 4-person household, that's about $35,000 per year. As of 2021, more than 270,000 people in our state qualified for free civil legal services. So that's about 14% of the folks in our state. We know that the need for our services is great. We received 18,000 requests for assistance last year. And unfortunately, we can't help everybody who comes to us because we don't have the funding to do that. So we were able to provide some form of legal assistance to about 13,000 people last year, but only in about 2,000 of those cases were we able to provide a lawyer to provide direct representation in court. And so when you look at that, that's about 15% of the cases we handle every year. And if you want to put that into further perspective, we are able to provide a lawyer for approximately 1% of all of the low-income people in our state. So those numbers are incredibly low. But we also know that the services we provide are impactful. They benefit individuals, they benefit the communities. I mean, we know that because we're tracking outcomes. And so in 2022, we were able to realize a total economic impact on behalf of our clients of about $10.5 million. About half of that was in helping them increase income, and about half of that was helping them decrease debt. And in more than 90% of our cases, we are able to successfully obtain a positive outcome for them. So our services are impactful. Can I have just one more moment to finish up? I promise I'll be quick.
2 sentences.
Oh, well, okay. I wanted to highlight for you all today that really this is all about, really, there's a huge demand for our services, but the funding that we receive, particularly through the Legal Aid and Services Fund, has significantly decreased. And so to illustrate that, in 2022, we received about, it was nearly $400,000 less than we received in 2018. That has a significant impact on our budget. And so Legal Aid of Nebraska, of course, heavily supports LB 555. I want to thank you for the opportunity, and I'd open it up for any questions.
Are there any questions for this testifier? I don't see any. Thank you so much for being here.
Thank you so much.
Next proponent.
Good afternoon, members of the Judiciary Committee. My name is Destiny Fant, DESTINYFANT. I live in Omaha. I am a client-eligible lived experience board member of Legal Aid of Nebraska, and I'm testifying in my capacity as a Legal Aid board member. I'm pleased to give this committee a perspective about legal aid that you may not already know. I work for the nonprofit organization Together in Omaha. Together's mission is to prevent hunger and homelessness in the Omaha area. I'm the Crisis Engagement Tenant Assistance Project Specialist. In my position, I attend eviction court in Douglas County 4 days per week to work directly with low-income tenants being evicted from their homes. Through this work, I know firsthand the significant challenges these individuals and families face beyond the eviction, including harassment from debt collectors, difficulties with their spouses and significant others and families, and loss of income and governmental benefits. Each of these challenges prevents them from caring for themselves and their children, perpetuating poverty. These low-income tenants have a lot of worries on their minds. They cannot afford lawyers to represent them, and this is where legal aid fits in. In this position, I work closely with legal aid. Legal aid provides a lot of services, but one in particular is the Housing Justice Project. I refer my clients directly to legal aid when I learn they're struggling to keep a roof over their heads or they do not have the money they need to feed their families. When they work with legal aid, they get an experienced lawyer and high-quality legal representation. I've seen firsthand hundreds of times people go from being terribly stressed over their immediate situation and desperate about their future to knowing their rights, having a plan, and doing what they need to do to help themselves. In addition, if they're being evicted, they almost always get to remain in their homes. If not, they are given time to relocate. This ensures a more seamless transition, lessening the negative impact moving can have on a low-income family struggling to make ends meet. And all of this is made possible through legal aid. Of course, you would expect that I would praise legal aid services due to my present role as a board member, but I have long known about and supported what legal aid is able to do for low-income Nebraskans. In fact, I was once a client. Legal aid assisted me and my children. They helped me obtain custody of my son as I escaped an abusive relationship. They helped me and my children obtain safety. My attorney with legal aid was skilled, caring, and respectful. I'll always be grateful for this help, for without it, I would not have custody of my son today. Legal aid simply helps people deal with their critical legal problems and get a measure of fairness in court. I know, though, that only a fraction of Nebraskans who need these services can get it due to limited funding. An increase in funds to the Legal Aid and Services Fund through LB 555 is a really minimal and simple way to get more funding to legal aid and its partners across the state. I encourage you to advance LB 555, and I'd be happy to answer any questions you have. Thank you.
Are there questions for this testifier? I don't see any. Thank you so much for being here.
Hello. Can I start?
Yes, welcome.
All right, good afternoon, members of the Judiciary Committee. My name is Liz Neely, L-I-Z-N-E-E-L-E-Y. I'm the Executive Director of the Nebraska State Bar Association, and here today in support of LB 555. Just outcomes in the criminal justice system require capable counsel for both the prosecution and the defense. The Commission on Public Advocacy was created in part as a way to provide property tax relief and to protect smaller counties from bankruptcy. Prior to the commission, a small county could go broke covering legal fees associated with just one capital case. The commission, as you've heard, is currently understaffed, and without an increase, they'll have to further reduce services available, thereby increasing costs to counties. These are complicated cases. The stakes are high. Having a Commission on Public Advocacy also helps ensure that the lawyers providing representation in these cases are well-trained and experienced. If quality representation is not provided on the front end, then counties can expect a claim of ineffective assistance of counsel and incur additional legal fees on appeal. The commission is funded from court filing fees, and over the years, they've been asked to take on additional functions without additional funding. Court filings have been steadily decreasing over the past 2 decades, and the situation has really reached a crisis level. Several bills have been introduced this session to address funding for the commission, but LB 555 and its companion bill moved the commission from a filing fee system to a general fund appropriation so we can bring stability to the organization. If the commission continues to be solely funded by filing fees, we're going to be back here in a few years because filings will continue to decrease and they'll need additional funding. This bill also directs excess funding to the Legal Aid and Services Cash Fund. That's also funded on filing fees, and I've provided you a chart to show you how that Legal Aid and Services Fund has also experienced a very sharp decline in revenue. We're trying to do more with a lot less in that fund. Although our primary source of funding for Legal Aid of Nebraska and the Volunteer Lawyers Project through the Bar Association is the Legal Aid and Services Funds. It's important that we continue to fund those. Due to limited resources, we're currently turning away thousands. This bill could change the landscape by making more money available to help low-income Nebraskans, people who are facing homelessness, job loss, domestic abuse, custody issues that have nowhere else to turn, and we strongly encourage your support of LB 555.
Thank you so much. Are there any questions? Doesn't look like that generated any questions, but we appreciate you being here.
Thank you.
Next proponent testifier.
Why I should go a little different direction. My name's Charles Liske, CHARLESLIESKE. I'm Executive Director of Mediation West in Scottsbluff, and we're approved by the State Court Administrator's Office to provide mediation services to 15 counties in western Nebraska. And since it was created, we have received funding from the public advocacy grant process to supplement us. And in more than one instance, Nebraska has structured funding programs that relieve burdens to the courts through court filing fees. And at first, this process made sense 25, 30 years ago. But as these programs have been successful in diverting conflict from coming before the court, and the would-be litigants are finding resolution at an earlier stage, the funding for these programs is reduced along with those reduction in filing fees. So as legislators, I know that you take your fiduciary responsibilities seriously, but I urge you to support this request because this funding up front reduces costs to the state by helping litigants resolve problems outside the judicial system, and formal court processes cost a lot more. So each year, our center has needed funding at 3 to 4 times the level of what the commission has been able to provide us through their grant process, because at any given time, we are serving 2/3 of our clients are falling below that 125% of poverty level. It's another thing to consider that a lot of our clients are not represented by counsel. They are pro se. And so when they don't have an attorney and they're not using an organization like ours, then they're taking additional court time, court staff time to get their questions answered. And that's another burden. So we support in our organization families that are trying to learn how to parent from 2 homes, families that are involved in child welfare and juvenile justice system, and just general community disputes that are better resolved when people can get to those underlying interests that are needing to be addressed rather than just getting a judgment from a court. One great example, we had a case at the end of last year. There were a total of 8 protection orders in district court for some folks going through a fence dispute. And when they came to our center and went through mediation, they reached a full agreement and dropped all 8 of those orders. And there's lots of other work that we do at restorative justice where we're working on reparations. I know you talked about reparations in an earlier bill. But I'd be happy to answer any questions that you all have about how our services impact the community, or how an increase in funding through the Commission on Public Advocacy might have an impact on our organization.
Thank you very much. Are there any questions for this testifier? I don't see any. Did you come from Scottsbluff today?
Yes, so it's,
well, thank you.
The Commission on Public Advocacy is an important part of our funding stream, so it's worth the effort, definitely.
Thank you so very much for coming all the way out here and sitting here with us all day.
Yeah, it was an entertaining day.
Thanks so much. Are there other proponent testifiers? Is there anyone here to testify in opposition to this bill? Anyone here in the neutral capacity?
Good afternoon. My name is Spike Eicholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska in a neutral capacity to LB 555. I was not planning on testifying, but when I started hearing the description of the bill and some of the arguments we made, I wanted to be on the record on this. We are neutral in the sense that we do support the Commission on Public Advocacy. They do good work. What Mr. Pickens says, what they do is certainly true. They save counties money and they provide quality criminal defense. I'm not testifying right now on behalf of the Criminal Defense Attorney Association, but the attorneys in that office are members of that association. They are some of the best attorneys in the state that practice criminal defense, including Mr. Pickens. And the ACLU supports that organization. What we are concerned about and what we would first support and argue is that since they do provide a valuable resource to the counties and to the state and to the court system overall, that they should be funded by the general fund, by the budget of this state, and not rely on user fees or court fees to do so. The ACLU opposes an increase in court fees, and we generally are opposed to using court fees to fund necessary and quality government operations. Court fees are better to consider as user fees. We have a right to petition the court. The court fees are imposed in every case, not just criminal cases. I think most people think, well, if you don't want to pay the court fees, don't break the law. But it's imposed for every case. If you file for a divorce action, you pay court costs. If you file to register a trust with a court, you pay a court cost. If you get a speeding ticket, you pay a court cost. It's a user fee that's imposed on everybody. And like all user fees, they're standard and they hurt the poor the most. The legislature does not impose a user fee, right? If I want to testify on a bill, I've been doing it all day. I haven't paid anything, but admittedly, it costs this branch of government some money to do, and we don't consider that. Similarly, if I want to petition the court for redress and I just don't fight it out in the streets, I want to use the court system, I shouldn't have to pay a fee for that. That's our fundamental policy. It's a First Amendment principle, and it's basic. We have court fees now. We should not increase them. We already have a number of court fees that are earmarked for different funds. It's $3 on every case with the Commission on Public Advocacy. It's $6.25 for the legal aid fund. It's anywhere from $2 to $9 for a judge's retirement fund, depending on the kind of case. The fees can be significant for some people. We should not increase those. I know that this bill does not envision that necessarily, but at least that's one of the things that's being discussed. And so I just wanted to put that on the record, and I'll answer any questions if anyone has any.
Questions for Mr. Eicholt, Senator McKinney?
Thank you, Senator DeBoer. Thank you, Spike. Can you speak to how court fees hurt the poor?
You know, it hurts poor in a number of different ways. If you're charged criminally and for a traffic ticket, a simple misdemeanor, you're going to have a $50 court cost with it. That's in addition to any kind of fine. That's in addition to the bond that you might have to pay. That's in addition to probation fees. If you get a speeding ticket and you don't pay the amount that you owe on that ticket by a certain day, whether it's a fine or whether it's the court cost, your license can be suspended. You get your license suspended, you've got to pay the DMV to have it reinstated. Somewhere along the line, your insurance is going to be canceled, so you got to pay that company back to get your insurance reinstated. These things have an impact on the poor, and this is just part of it, and it's disproportionate to other people who are impacted by the court system.
Thank you.
Other questions, Mr. Eicholt? I don't see any. Thank you so much for being here. Any other neutral testimony? Welcome back to the Judiciary Committee.
Thank you. Good afternoon, Vice Chair DeBoer and members of the Judiciary Committee. For the record, my name is Elaine Menzel. It's ELAINE-MENZEL, here today in a neutral capacity on behalf of the Nebraska Association of County Officials. We're appearing here today in a neutral capacity because our focus isn't necessarily the legal aid provisions and the other aspects, but to emphasize the importance of the Public Advocacy Commission to the counties. I just will quick note a couple of things before I get further into what I've got going on, and that's to let you know what I'm passing out or having passed out to you. One of the It's an article related to Richardson County, which is the county that was referred to earlier as being broke, and in part the impetus for the creation of the Public Advocacy Commission. And then also, second, a chart with each of the 93 counties showing the number of attorneys in counties. It's as of June of last year. That information was provided from the Bar Association, but then it also shows all of the counties where work has been done by the Public Advocacy Commission. When I just glanced at what the committee makeup was in the work of the Public Advocacy Commission, they have done work in each of your counties, with the exception of 3 of the smaller populated counties in Senator Ibach's district. With that said, some of those, there's perhaps only been 1, but others, there's been a great deal. Interestingly, some of the counties that are surprising is a county such as Cheyenne, and I want to say it's roughly 80-some cases over the years. I believe that's since 1995 that chart shows that information from. Mr. Pickens also referred to the legislative findings when they created the legislation that created the Public Advocacy Commission. And again, it's related to property tax relief, but I'll jump to a piece that I believe Senator Blood will like, this portion of the study that emphasizes essentially through some of the findings and what indigent defense is. It's through the Constitution and court cases, and therefore a federal mandate passed down to the state, thus passed down to the counties as a result of providing defense, but also enforcing prosecution on the other side. So as you evaluate the issues within LB 555, please consider how invaluable the commission is to the clients first and foremost, but also to the, I see my time.
You can finish your sentence.
Okay. But also to the counties in terms of providing effective indigent defense for capital cases, and also providing a portion of property tax relief to taxpayers. If there's any questions, I'd be glad to attempt to answer them. Oh, one more, I'll be back on this issue with respect to the other bills that are addressing this.
All right, thank you. Are there questions? Ms. Pinzon? I don't see any.
Thank you
so much. Next, neutral testifier. Anyone else here to speak in the neutral capacity? I don't see any while Senator Cavanaugh is coming up. I'll just note for the record that there was 1 letter in support. Senator Cavanaugh.
Thank you, Vice Chair DeVore. And I don't have a lot more to say. I just wanted to draw your attention to, I assume this is the handout that Mr. Pickens handed out. It's the second to last page where you can see the filing fees from 2005 to 2022 and the continued decline in those filing fees. And the statement about what it would take in terms of an increase to get to what they need to operate. $8 from $3. That's more than double what they're bringing in now. And the reason for that is, as I think I wrote down his name, Mr. Liskey, I think was said about mediation and things like that. It is the success of these programs that we have, this committee has, to a great extent, put in place in the last decade or so to get folks to go to alternative forms of resolution. And it's decreasing the number of filings. And we have not stopped doing that. We were trying to get more programs that are going to get people out of the court system and to resolve these issues. And so if we need to fund the Commission on Public Advocacy, that's not a question. You can hear all those things. You can see the maps that were handed out. The service they provide is one that is of great value to the state of Nebraska. The question is, how do we do it? And the question is, do we recognize the value and do it as an essential function of the state of Nebraska and give it certainty so they don't have to continue to come back and have this conversation and increase it again and again? Because if you increase it $8, guarantee you that's not going to fund them in 5 years. They're going to have to come back and ask for either a supplement or an increase. And that is not a system to do this. So that's why I'm advocating for moving them to general funds. The other part about this is, obviously, I think if anybody knows me, knows I do not like court fees. I think you can figure that out from today if you didn't already know me. But this bill proposes taking a court fee that already exists and shifting it to another valuable service of the state. And so that is a situation which, I've got honestly mixed feelings about, right? I really appreciate the services of the legal aid and the other functions that this money goes to, but I'm of the belief that we should decrease court fees rather than increase them. But it is an opportunity at this point, if we do the right thing with the commission, rather than decreasing that court fee, we could fund some essential services. And I can tell you firsthand, I've seen a lot of the work that legal aid does in Omaha, and it is very valuable. And I appreciate the work they do. I would just point out, I didn't get much conversation, but another kind of technical aspect of this bill is that it allows for the commission to be funded through general funds. The commission has received general funds in the last couple of years, even though the statute has legislative intent in there that they should only be funded through fee. But as we all know, legislative intent is legislative intent. We can't bind future legislature. And so we did, as legislature, give them funding to get them back up to where they needed to be the last biennium. But this just clears that up and puts into statute that they can be funded through general fund in addition to fee funding. So that I take any questions.
Are there any questions for Senator Cavanaugh? I do not see any, Senator Cavanaugh. With that, we'll close on LB 555 and open on LB 27. Welcome to your Judiciary Committee, Senator Dungan.
Thank you, Vice Chair DeBoer. I'll let them file out. My opening's only about 60 minutes long, so you don't have to be here much longer.
You meant seconds.
Oh, right, that's it. Yeah. Exactly. Good afternoon, Vice Chair DeBoer, maybe good evening, and members of the Judiciary Committee. I'm Senator George Dungan, Georgedungan. I represent the people of Northeast Lincoln in Legislative District 26. Today I'm introducing LB 27. LB 27 is a bill to allow for the appointment of legal counsel in cases where the prosecutor appeals a decision to the appellate courts or other courts. It also removes the $200 compensation cap and allows the court to set the compensation for the appointed attorneys. Under current law, if a prosecutor wishes to appeal a trial court's ruling or decision to the appellate courts or to another court, the trial court may appoint an attorney to argue the case against the prosecutor. However, Section 292318 only provides courts with the authority to compensate an appointed attorney $200 for the entire appeal. Additionally, that section, along with others that correspond in the Nebraska revised statutes, do not provide for a court to determine whether a defendant is indigent or to provide for appointment of a public defender in such an appeal, even if the public defender had previously been representing the defendant. LB 27 would allow the courts, if they determine that a defendant is indigent, to appoint the public defender or, in counties without a public defender, an attorney licensed to practice law in that state in order to argue the appellate case. The court shall appoint another attorney if the public defender or the attorney has a conflict of interest. An attorney other than the public defender appointed under this section may be compensated as the trial courts deem appropriate for all fees and expenses reasonably necessary to permit such attorney to effectively perform the appeal. If the trial court does not find that a defendant is indigent and does not appoint the attorney, the defendant may still be represented by an attorney of their choice at their individual expense. If the trial courts determine a defendant is indigent, LB 27 allows the appointment of a public defender. In counties without a public defender, trial courts would appoint an attorney licensed to practice law in the state. The appointed public defender or attorney would then argue the appellate case against the prosecuting attorney. Members of the judiciary, I know it's kind of complicated and you're probably very tired. I know it's been a long day. Essentially, when a case is being appealed, if the defense appeals the case, their attorney, their public defender, whomever is representing them can continue to represent them. The law is a little bit strange, and it's frankly, I think, a little bit antiquated and written weirdly when the prosecution appeals the case. That's the statute we're looking at here, is if the prosecutor appeals the case, I believe the current statute is insufficient in terms of actually allowing that person to be appointed an attorney if they're deemed indigent, or allowing them to hire their own attorney. And most problematically, it caps their payment at $200. My understanding, and folks who are going to testify here briefly after me have better examples probably, but there are examples of this happening where the prosecution decides to appeal and the court reaches out to attorneys who turn the case down because they say $200 is insufficient payment for me to handle this entire appeal. So effectively, it becomes difficult in certain counties for folks to have representation in cases like this where the prosecution is appealing the case. The amendment I've handed out changes things just slightly. Effectively, what it does is it adds the language in that's important into an additional part of statute that was neglected in the first one. So it's sort of two separate parts of the Nebraska revised statutes that both have to be modified to make this change happen. And most importantly, it essentially adds this extra step where the courts need to reach out to the attorney or the public defender's office first and say, hey, can you handle this case? Are you capable of taking this on with your current caseload? And if they say yes, then they can be appointed. So it's just adding that extra check to make sure that attorneys aren't getting this case added to their caseload and then subsequently have to file motions to conflict out or overload out or something like that. So it's mostly procedural. The effect with the amendment is still essentially the same, which is that we're trying to make sure folks have representation in the circumstances that a prosecutor appeals a matter to a higher court or a court of appeals. Happy to answer any questions if you have them.
Okay. I see
Just a
Senator
brief
Grice.
one. I will just make it short. Does this happen very often?
No.
Okay.
And that's part of why I think that's a very good point. And I think some folks after me probably have some better numbers. I know we reached out to the clerk of the district court here in Lancaster County, trying to find out how often this happened, because we had concerns about fiscal loads and impacts and whether this was going to add a big
Which was
case
going to
load.
be my follow-up.
Yeah. What we heard back was that I believe Troy Hawk told us this has happened maybe 2 to 3 times in the last 5 years where it's been appealed to the Court of Appeals, and then maybe once or twice from the county court to the district court. Maybe I'm flipping those, but we're talking
Rarely.
5 or 6 times this has happened in the last 5 or so years.
So we're not passing a huge unfunded mandate down to the county. I guess that's.
Correct. And that's, I think, a totally valid concern. But no, my understanding, looking at the actual data, is this happens rarely enough that it wouldn't be a huge unfunded mandate. And I think where it comes into play in particular are these more rural counties that don't have public defender offices.
Yeah.
So if the prosecutor decides to appeal this case and you reach out to some attorney on the appointment list in that county and say, hey, can you take this on? And they say, not for $200, I can't.
Yeah.
And then you can't find anybody in the entire area. So you effectively run into this problem with lack of payment and lack of attorneys that can take these on, where if the prosecution appeals a matter, which they're completely within their rights to do, there may not be somebody to represent that defendant or to argue against that in the higher courts.
Yeah, gotcha. Thank you.
Other questions for Senator Dungan? I don't see any. Are you going to stay around to close?
I'll stick around. I'll probably waive it, but I'll just listen here. So
All right.
Thank you.
First proponent testifier.
Good evening. My name is Spike Eichholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the Nebraska Criminal Defense Attorneys Association. I want to thank Senator Dungan for introducing the bill. Senator Dungan explained the purpose of the bill. As to answer Senator Guy's question, this does not happen that much. And the reason that it's sort of an odd scenario now is because if the state decides to appeal a ruling from the trial court, and it could be an instruction that the judge gave to the jury that the prosecutor is unhappy with, or it could be a ruling on a pretrial motion to suppress or something like that. If the state appeals that, the state is appealing a case that they have lost. So the defendant in that case is free. They cannot be retried. They are done with the case. They don't have any interest in appealing. And they aren't entitled to necessarily have a lawyer appointed to represent them since they're not in jeopardy. The interest that our association has, and we're about 370 attorneys across the state who practice criminal defense, some full-time public defenders, some private lawyers who do it part-time, is that you have these, even though they're frequent cases, these cases going up on appeal that perhaps may not be completely fully argued. and briefed to the appellate court. And a Supreme Court or Court of Appeals ruling may have consequences to other cases pending that our association might have an appreciation of. I didn't immediately realize that the statute was like this. I've never been involved in one of these kind of cases myself or had any of my clients be involved in it. A judge who tried to appoint the Commission on Public Advocacy over the summer, and Mr. Bickens explained they just could not do it, was looking around and actually contacted me to see if I could find a lawyer that would do it for $200. And he directed me to the statute, and that's where our association got involved in it. I think somebody was able to step up and do it. If you look at the statute, it just says something odd, like the court can appoint somebody of the defendant's choosing to argue against the case. That's odd because you normally don't get to choose your lawyer in an appointment situation. And I suspect, I think Mr. Hruza might know for sure, that the statute that provides for this option to appoint a lawyer to argue against the state was before we even had the public defenders in our state. I think in 1974, the state legislature passed a bill to create the public defender system, and I suspect this bill was written, or this law was written before that. So it's not, I come up here to argue about lessening penalties and arguing against increasing penalties. That's not what this is. This is a procedural thing. It's a small thing. But it could be a very consequential thing, so we'd ask the committee to support it. I'll answer any questions if anyone has any.
Any questions for this testifier? I don't see any. Next proponent testifier.
Madam Vice Chair, Mr. Chair, members of the committee, my name is Tim Hruza, last name Hruza, appearing today on behalf of the Nebraska State Bar Association in support of LB 27. I want to thank Senator Dungan for introducing the bill. This is my first time appearing before you. I know you've heard some of our members come up at various times, but the Bar Association represents all attorneys from across the state who are members of our association. We take positions on legislation, generally in areas or bills that a very large committee of attorneys and our eventual House of Delegates, which is an elected body of the bar, determines to be generally in the interest of justice, of access to justice and in the furtherance of justice. So I appear today before you in support of the legislation after some long discussion about kind of what the bill does, what its intent is, and then I'll provide you a little bit of background. We're working on an amendment to the bill, and I think Mr. Eichel kind of previewed that for you, but there's actually two provisions in statute that set this fee, and it's capped at $200. The best research I could do is could find was that statute was initially passed in like 1959 to set that $200 cap on these types of appeals. Obviously a very different amount in 1959 than that amounts for attorneys nowadays. So when you look at an attorney who's appointed for these cases, if a public defender can handle it or the Commission on Public Advocacy can, they will. Those are the ones that go to first, right? But in the event a private attorney needs to be appointed, just as in any other case where a private attorney is defending or appointed in furtherance of justice, we do believe they should be paid for their time. So that's why I appear before you today. We're working on some technical language to help make sure that we're not kind of upsetting the apple cart too far, right? The intent is just to ensure that attorneys who are appointed to these cases take them up, defend the interest of justice, I guess, from the trial court to whatever the appellate court level is. And that's why there are two statutes, one for an appeal from the county court to the district court, and one then from the district court to the appellate court, so the Court of Appeals or Supreme Court, right? There's various levels that you can go up through the trial court depending upon where the case originates. That's why we'll have an amendment that deals with both of those where it is capped at $200. So with that, it's pretty straightforward. Appreciate Senator Dungan's interest in the bill and yours as well. And we would ask that you advance LB 27 with our committee amendment that is yet to come to general file.
All right, are there questions for Mr. Hruza? I don't see any. Thanks for being here.
Thank you.
Other proponent testifiers? Are there any opponent testifiers? Is there anyone here to testify in a neutral capacity? While Mr. Dungan is considering his closing, I will say that there are 2 letters of support. And Senator Dungan waives closing, and that will end our hearing on LB 27 and will end our hearings for the day.